Yeah,
Testing, testing.
we'll take two unless more people come up.
Testing, testing.
Okay, we're on the record for case number 9666, the application by U.S. Wind for revised round 2 offshore wind credit, and we'll take appearances.
Good morning, Mr. Chairman, Commissioners. I am Carville Collins on behalf of U.S. Wind. Also appearing for U.S. Wind, but not at the table at the moment, Sunu Pillai and Anamika Moore.
Good morning, Mr. Chairman and Commissioners. My name is Tom Previs. I'm also appearing on behalf of U.S. Wind, both for the law firm Saul Ewing.
Good morning, Chairman and Commissioners. William Fields for the Office of People's Counsel. I'd also like to enter the appearance of David Lapp, People's Counsel. And here with me today also is Ryan Shue.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. Staff filed a notice of appearance this morning, so I'd also like to enter the appearance of Harrison Scher and Lloyd Spivak, who won't be here.
Okay. Anybody? Oh.
Good morning. Sorry, Amiel on behalf of Sierra Club.
Good morning, Tim Oberleiten from Earth Justice on behalf of
Actually,
sorry.
yeah.
Tim Oberleiten from Earth Justice on behalf of Maryland League of Conservation Voters.
Actually, you can go to the podium there, a little easier for you.
Okay, thank you so much. Good morning, Chair Hoover and Commissioners. My name is Emily Vinieri, and I'm here on behalf of the Maryland Department of Natural Resources. Thank you.
Going once, going twice. Okay. Mr. Collins.
Mr. Chairman, thank you. I have a preliminary matter, which is to introduce a few things, mark them and move them into the record that are sort of fundamental to our case. And with the Commission's permission, I'd like to first mark the application that has been filed with the Commission on July 30th, 2024. There are actually two versions, a public version and a confidential version. I would ask that the public version of the application filed on July 30th be marked as U.S. Wind Exhibit Number 1, and that the confidential version of the application, also filed on July 30th, 2024, be marked as U.S. Wind Exhibit Number 1C. And if there are no objections, I would ask that they be moved into the record.
My only question is, why 1C?
1C just to indicate the designation that it is the confidential version. So we would have 1 and 1C is our proposal.
Okay, I just want to, yeah, because I assume there's going to be other confidential things, so.
There will be.
So I guess, this is going to create, sort of a precedent as to how we're going to handle these things going forward. So just so
Yes.
everybody else kind of understands the same situation. Okay, fair enough.
And we will maintain that consistency throughout with our other confidential exhibits. Thank you. Also, the next exhibit would be the appendix that accompanied the application. There were two versions of that as well. A public version dated July 30th, 2024. We would ask that that be marked as U.S. Wind Exhibit Number 2. And the confidential version of the accompanying appendix, also filed on July 30th, 2024, be marked as U.S. Wind Exhibit Number 2C. And if there are no objections, I'd ask that they also be moved into the record.
Okay, so I actually didn't rule on 1, so 1C, 2, and 2C are all marked, and seeing no objections, I'll admit it. So.
Thank you, Mr. Chairman. Just a couple more. On August 14th of 2024, U.S. Wind filed errata, picking up just typos and slight errors to the application and appendix. That errata, again, was filed on August 14th, 2024. The public version we would ask be marked as U.S. Wind Exhibit Number 3. And the confidential version of that errata, also filed on August 14th, 2024, be marked as U.S. Wind Exhibit Number 3C. And if there are no objections, I would ask that those two be moved into the record.
Okay, so marked and so admitted.
Thank you. And then finally, on October 15th, 2024, U.S. Wind filed certificates of publication indicating publication of notices for the evening public comment hearing that occurred on October 16th. We would ask that the certificates of publication filed on October 15th, 2024 be marked as U.S. Wind Exhibit Number 4. And if there are no objections, would ask that that be entered into the record.
So marked, so admitted.
Thank you. That dispenses with the preliminaries on evidence. We are prepared to call our first witness if the commission is ready.
Go ahead.
I would ask that Mr. Jeffrey Grabowski come to the stand.
Please raise your right hand. Do you solemnly affirm on the penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Jeffrey Grabowski, Jeffrey Grybowski. I'm the Chief Executive Officer of U.S. Wind. Our address is 401 East Pratt Street, Baltimore.
Thank you.
Good morning, Mr. Grabowski.
Good morning.
Do you have before you your written direct testimony in this case,
I do.
consisting of 20 pages dated September 6th, 2024?
Yes.
And do you also have before you your written rebuttal testimony in this case consisting of 12 pages dated October 21, 2024?
Yes.
Was this testimony prepared by you or under your supervision?
Yes, it was.
Do you have any corrections, changes, or updates to your written testimony, particularly the direct testimony confidential version?
I do not.
Just a page numbering on the confidential version, if I may remind you.
Yes, thank you for that reminder, Mr. Carville. Apparently there is a mispaging on the confidential version towards the end, where page 18 should be. It starts renumbering page 1.
So the last three pages should be pages 18, 19, and 20?
Correct.
And that is of your direct testimony confidential version, correct?
That's right.
Thank you. Is the content of your written testimony true and accurate to the best of your knowledge, information, and belief?
Yes, sir.
Would your answers in this written testimony be the same today as when you wrote them?
Yes.
Mr. Chairman, I would ask that the direct testimony of Jeff Grabowski be marked as U.S. Wind Exhibit Number 5 for the public version and U.S. Wind Exhibit Number 5C for the confidential version, and if there are no objections, moved into the record.
So marked and so admitted.
Thank you. And I ask that the rebuttal testimony of Jeff Grabowski, which is a public version only, be marked as U.S. Wind Exhibit Number 6. And if there are no objections, moved into the record.
So marked, so admitted.
Thank you. Mr. Chairman, U.S. Wind has a brief rejoinder for this witness.
Okay.
Mr. Grabowski, based on the application and testimony of U.S. Wind and the responses from the parties on issues of pricing and conditions, and for the benefit of the commission, could you give a brief general overview of the project and the reasons for the pricing and conditions that U.S. Wind has proposed?
Sure, happy to. We understand that this is a very substantial and important project for the state of Maryland. And we really tried to address three important goals in this application, very broadly speaking. First, we were very cognizant of the fact that the state lost one other project very recently that was under contract here before the commission. So our first goal was to try to replace as much of that capacity as we could in order to assist the state in meeting its goals. In order to do that, we dedicated the entire wind energy area for Maryland. So previously, under contract, we had about 2/3 of the wind energy area that were covered by ORECs. We, in this new application, increased that to 100% of our lease area. So we've offered to the state everything that we have to give in terms of the capacity of our site. So that was one goal, to try to replace as much capacity as we could. The second goal was to maintain our economic development commitments and, where appropriate and possible, to increase them. And we have proposed a larger amount of in-state spending than previously, and we've maintained our commitment to Sparrows Point Steel and also sponsored the construction of a second facility, a cable facility done by Henlock Cable. So those were two important sort of foundations for what we were trying to put together. And then based on that, we spent a lot of time working on the set of conditions and pricing that would allow us to deliver those two things. And I think, as I'm sure folks have seen in the application, and I'm happy to speak about today, that required some changing to the pricing. In round one, we were able to reduce our pricing from the maximum that was allowed in round one. And in round two, we had to increase the pricing. And really the goal was to reset these projects and to create some durability in the state's offshore wind program. I think in the last 3 or so years, we've seen projects in the U.S., offshore wind projects, that were previously announced and secured contracts, back out of contracts. It wasn't only in Maryland. It happened in New York, in New Jersey, in Massachusetts. And that was a consequence of what we all as a society went through over the last few years with inflation and interest rates and supply chain constraints. So we've seen projects up and down the East Coast readjust pricing, schedule, and that's what we've done here to align our projects with what I would say is a new reality. And so where we were able to reduce pricing, we did so. Where the market has required us to increase pricing, we've done that. And so that's what we've done here today, and I'm happy to go into further detail, obviously.
Thank you. Mr. Chairman, the witness is available for cross-examination and other questions.
Okay, Sierra Club.
Good morning, Mr. Grabowski.
Good morning.
I do have a few questions for you, but really just a few. So this should be pretty quick. So U.S. Wind's first offshore wind project, Marwin, is expected to come online by December 2028, correct?
That's our plan, yes.
And Momentum, which is now phases 3 and 4 of U.S. Wind's projects, is expected to be operational by December 30th, right?
2030.
Or 2030,
Yes.
that's what I meant. Okay, thank you. When U.S. Wind came before this commission for its earlier OREC proceeding, Marwin was originally supposed to have a commercial operational date of January 2020, right?
I will take it, subject to check, I will agree with you, but yeah, I think so.
Thanks. And Momentum was originally, subject to check, supposed to be commercially operational by December 2026, right?
That sounds right, yes.
Are there any existing legal requirements that require U.S. Wind to complete any of its projects by a certain date?
I'm not aware of any, no.
Okay, so there wouldn't be legal consequences from this commission if U.S. Wind misses the proposed December 2028 or December 2030 anticipated operational dates, right?
Well, I think the way the OREC program is designed, and obviously I'm not testifying as a lawyer here giving you my legal opinion, but my understanding is that the OREC program establishes an estimated COD, and to the extent the project does not meet those estimated CODs, there are provisions in the regulations that allow for later COD. At some point, I believe the commission has the ability to say, you no longer can hold the OREC. But there's a process in place to deal with those issues.
Okay, thanks. And the commission hasn't imposed any deadlines for intermediate deliverables for U.S. Wind's projects, such as, for example, a deadline for U.S. Wind to start construction, right?
No.
U.S. Wind does have an existing reporting requirement, which is a quarterly reporting requirement from this commission, right?
Correct.
And the quarterly reports include updates on the timing of U.S. Wind's permitting applications, right?
Yes.
And the timing of its interconnection requests to PJM?
Yes.
Are those quarterly reports also required to include updates on the construction process and timeline?
I believe we do address our activities related to construction as well.
Okay. So if, for example, construction was delayed by a few months, would U.S. Wind be required to note that in a quarterly report?
If we had that level of certainty, yes.
Okay. Is that a legal requirement or the best practice you would aim to adhere to?
I would say we generally try to use the quarterly reports, and I believe we actually submit monthly reports to the commission. We try to communicate to the commission things that are substantively important about the project to try to keep the commission and others informed about the status.
Okay, thanks. So maybe you just answered this, but
Yeah.
my last question, would you be amenable to a requirement from the commission that U.S. Wind should include in these regular reports information about any delays in the construction process?
I would not object to that, no.
Okay, thank you. No further questions.
Earth Justice,
No questions.
Office of People's Counsel.
Thank you, Your Honor. Good morning.
Good morning.
I'm William Fields for the Office of People's Counsel. I think I asked you questions some time ago.
I believe you did, sir. Yeah.
In some earlier iterations of this. I did want to ask you a few questions about, in your rejoinder this morning, you talked about 3 items, and the third one was the resetting of the prices for a new reality.
Yes, sir.
And I guess my question is, has the company been able to take measures to lock in, for want of a better phrase, your cost, and so that that we won't be facing a new reality
Right.
in some time in the near future.
I think the reality, Mr. Fields, is that sometimes locking in your costs makes sense. Other times you might be locking in your costs at precisely the wrong time. And so our approach to this project and this new application is to set a COD for phase 1 and subsequent phases that gives us enough time to actually negotiate. And so if we were try to get to a COD as quick as humanly possible, our options contractually would be quite limited, and we would likely be forced to take whatever price, whatever contract was on the table. We need enough time to put together the right set of contracts that keeps costs as low as possible. So the offshore space is unique. We're not buying commodities, right? We're buying highly specialized pieces of equipment. We're hiring very specialized contractors. Their availability is quite restricted. And so if you force us to make a lot of decisions very quickly, then we're very likely stuck with very high price levels, really bad terms. So our plan is to use the time that we have very, very carefully to put together a set of contracts that really works for the project and not be forced into a situation where we have to take the highest price that's on the table, which in general, the more flexibility you have, the more time you have, the better able you are to piece things together. And the more restrictions we have and the more tightly constrained the project is, the more likely we are stuck with a bad set of contracts. So I know that's a long-winded answer, but it's flexibility is quite important in our business.
No, thank you. That's helpful. the I think you mentioned this in your answer, but the contracts you're talking about negotiating, you said for equipment and specialized labor or contractors to do specialized things. So would that include the turbines themselves?
Yes, sir.
And would it include the ship that's going to come out and put them up?
Absolutely.
Okay. And that would include the transmission work to bring it on shore, the substation and the transmission work to bring it on shore?
Yes.
Okay. So those contracts, I think what you're saying is those contracts are to be negotiated. And so should I take it from that then that the prices that you have presented are your best estimates at this point of where those contracts are going to be, what you'll be able to do with them in aggregate?
Yes, that's fair. And if I can give a bit of context there, we are very much engaged in the market right now. And so we are talking to all of the major vendors. We've just received responses from the 3 major turbine vendors who've all offered to provide turbines for this project on our schedule. We're evaluating those offers right now. The process of negotiating a turbine contract will probably take 9 months to fully negotiate. It is a large number. Just for Marwin, it's a 9-figure contract, so it's quite complex. And the same is true for installation services, all of those things you mentioned, sir. We have been very engaged with the market. I have a full team that's not sitting in Baltimore today, that's sitting at a conference in Atlantic City today where the offshore wind industry is gathering. The technical folks are gathering to talk about vessels and things like that. And so we're actively interviewing contractors and suppliers right now. So our estimates are informed by all of these discussions, and Mr. Filippelli, who's our technical director, who will testify later, can certainly talk about sort of the creativity from an engineering perspective that you have to put in place to try to get the best set of contracts and the lowest cost possible.
Thank you. And the discussions with the 3 turbine vendors, could that result in a different size turbine, a different configuration of turbines?
Yes, within the boundaries of what is called the project design envelope. So through our federal permitting process, the federal agencies don't initially provide a permitting approval on a specific turbine model. What they approve is the maximum dimensions of the turbine, right? So from a permitting perspective, they don't care whether there's a GE label on it or a Siemens label on it. They care about what's the total size of the turbine and what are the main characteristics. So the federal agency evaluates the characteristics, the maximum sort of impacts of the turbine, and we can pick any size turbine or any model that fits within that envelope. And so it could be a 14.5 megawatt machine or a 14.7 megawatt machine. From a permitting agency, it doesn't really matter much, and the vendors sort of change their designations every other week, it seems. So we need a lot of flexibility to keep up with which models they're offering. Ultimately, before we're actually able to install a specific turbine, there is a separate federal process where a different arm of the federal government specifically authorizes that particular machine based on their review, their engineering review, right? So it needs to be certified by certain international agencies. It needs to be demonstrated to be a reliable machine that meets all of the various electrical codes and mechanical codes. So up front, we're given a lot of flexibility, and that's what we've asked for here, to stay within this envelope. So any machine that fits within the envelope, ultimately before we actually install the machine, we have to demonstrate that the machine itself has been certified.
Thank you. Do you happen to remember that other arm of the federal government?
Yeah, it's called BSEE. It's the Bureau of Safety Environmental Enforcement, BSEE. It's an arm of the Bureau of Interior, Department of Interior, excuse me.
Okay. Thank you very much. That's all my questions.
Thank you, sir.
Actually, I skipped DNR. Did they have any questions? Okay. Staff.
Good morning, Mr. Grabowski.
Good morning.
I'm Michael Dean. I'm with the staff. In your rebuttal testimony on pages 9 through 11, you have you note your opposition to the recommendation by the Maryland Energy Administration to require a condition with a $5 million deposit.
Yes, sir, I recall that issue.
And you didn't propose any text changes to make it such that you could support it. You just had an opposition to that. Is that correct?
Yes, sir.
Okay, thank you. And on pages 11 through 12, for the proposed condition of staff witness Lowe in his testimony, and your testimony is that it should be understood to apply to each phase of the construction,
Yes, sir.
but you didn't propose any text changes to the condition. Is that correct?
I think by my testimony, I was making the suggestion that the word by phase be included in the condition.
Thank you very much. Staff has no further questions.
Mr. Fleischman.
Good morning, Mr. Grabowski.
Good morning.
I can tell you that I've never asked you any questions since this is my first WIN proceeding. So actually, I guess what I'm going to ask is just to get a little bit better background. Since
Sure.
I'm
Yeah.
sort of still coming into this. We're looking at this point at a total capacity of 1,710 megawatts for the 4 different phases of the project.
Correct.
So we've got Marwin 1 that's coming at the end of 2028, and then the other 3 are going to come at the same time.
Together, yes.
Okay, so as of the end of 2030, all 3 of the sort of about 1,400 megawatts are going to come on at the same time.
Correct. That's the
Okay.
plan. Yep.
And is at this point there are no expectations, or at least you're assuming there are not going to be any delays. That at this point now you're ready to go for the full 1,710 megawatts.
Correct.
Okay. Just so that I have a sense of how your project, how you're trying to make your project economic,
Yeah.
in comparison to installed capacity or more conventional capacity. So you're relying on the OREX.
Correct.
You're getting a production tax credit.
Investment tax credit,
You're
which
getting
is
an investment
similar to the production tax credit, but is based not on the production tax credit is a federal tax credit.
Right. No, I understand how they work. So,
Yeah.
So as other wind facilities onshore get production tax credits, you get an investment. It's 30%.
You can opt for either the ITC or the
Or
PTC.
Okay.
So that's an option that any developer, any wind or solar facility can choose either the investment tax credit or the production tax credit.
Okay. So and this is 30% tax credit for the.
So the actual tax credit amount is attorney's eyes only, I believe.
Okay. That's fine. I actually don't. I don't know, but I'm just trying to sort of get a sense of how the project
But
is.
yes,
Okay.
so there's an important federal tax credit called the investment tax credit
Right.
that is in a sense supplemented by the IRA, the federal IRA law, which increased the value of the tax credit north of 30% if you meet certain conditions.
Okay.
And so we've made some assumptions about what level we're aiming for. And that's a very important part of the economics of the project. So the project economics are supported by the investment tax credit, and the ORECs are the guaranteed revenue stream that allows us to raise financing to actually construct the project up front, like a traditional renewable project of, frankly, any kind.
Okay. And then no purchase power agreement. So
No.
So all of everything you're generating is going to be sold in PJM market.
Correct, for the benefit of Maryland.
Okay.
Yep.
Is there any sort of flexibility? I mean, you spoke earlier about
Yeah.
the need to adjust the ORECs to reflect current market conditions. Is there anything within the contracts that would allow for adjustments of the OREC to reflect conditions within the PJM market? Or are you just sort of hoping
No.
that the market works in the way that you're anticipating that it'll work?
So the OREC is a fixed price that the state offers that the state pays the project in exchange for every unit of power we produce. So we cannot take that PJM risk. Right? That's the purpose of the OREC. It's to fix the revenue stream for a fixed price. We're selling our products into the PJM market. The value that we receive for those products is then essentially transferred to the state. So the ratepayers get the benefit of the energy capacity and RECs, and that helps from a big picture perspective offset the cost of the ORECs, which is a fixed price that's given to the project.
Right, but you yourself testified earlier that you're asking for adjustments to the OREC
Yes.
to reflect changes in market conditions. There's delays in the project are allowing you to come before us to ask for changes to the OREC. And I'm just sort of asking, sort of long term, to the extent that there are conditions in the PJM, and it's going to be energy market. You're not going to participate in the capacity market. You're going to be doing both.
We will get capacity credit, yes.
Okay. So if there are sort of, I mean, we sort of just watched in sort of horror at the most recent capacity auction.
Yes.
So things can go in one direction, but they could easily go in the other direction. Are you so the OREC that we set now, that's set, and you won't be able to come back to us and
Correct.
Okay.
Yeah, because when I say the resetting of the OREC price based on changes in the market, I'm actually not referring to the PJM market. I'm referring to the market to build an offshore wind project.
Yeah, no, I understand this changes in steel prices.
Exactly.
And, right.
Right.
No, I'm mostly I'm just trying to sort of have a sense, sort of looking forward. Whatever we agree to, whatever we issue in our order, you're committing to being stuck with that.
Correct. That exactly.
Okay. All right. That's all I have. Thank you.
Mr. Richard.
Good to see you again. And
How are you, sir?
I think we last had this, was it 2017 or 2018? So
Yeah, I don't recall at this
we
point.
have, so yeah, we have been through these. I guess the only question I would just really around the OREC itself.
Yeah.
Since that 2017, 2018, there have been a few projects that have come online on the East Coast. Have we really tested the OREC as far as a mechanism? Is that working anywhere else at this point, or have other states gone in a different direction as far as our purchase agreements? I'm just trying to figure out, now that we have some experience on the East Coast, if this is still, in your mind, the right way to go.
It's an interesting question for sure. I would say it's a very active debate among developers and policymakers. I think there are pros and cons here. I think some of the initial projects that have gone forward are, so the Vineyard Wind project is in construction. The South Fork Wind Farm, which I initially developed, is now in operation. It's off the coast of New York. And the Revolution Wind Farm, which I also helped develop, is in construction off the coast of Rhode Island. Those are all PPAs. Those are all power purchase agreements. However, I wouldn't draw the conclusion that PPAs are necessarily better. I think the fact that those projects are in operation is simply because they were contracted earlier, and the permitting went a little faster up there. So I think that projects can be supported by either PPAs or ORECs. I think at the state level, when you have many utilities, if you've got one utility, then a PPA directly with the utility may make sense if the right legislative authority is there. But if you have multiple utilities, multiple load-serving entities in a state, then we would need a whole set of PPAs with each one of those load-serving entities, and sort of a joint sort of procurement process that then comes together. The utilities then, you're adding an extra level into the process, right? So you've got an authorization, you'll have some kind of competition, a selection process somehow. Do the utilities get to select? If you're in your pre-PPA world, you're giving utilities potentially the ability to say yes or no to offshore wind. Some states may not want utilities to be able to say yes or no to offshore wind. And then you have a whole negotiation process, which is likely going to add quite a few months to the process. So there's some downsides to the PPAs. An OREC process is more of a centralized, state policy-driven process, and we have, New Jersey copied Maryland back in the day. So Maryland had the first OREC program. New Jersey copied it essentially, and they have some projects under contract. They're not built yet, but I do expect that they will be built. So that's a long-winded way of saying there are pros and cons. I think from the perspective of really standing up an entire industry, I think because offshore wind projects are so large and complex, I think the central role of state government in setting the policy is quite important. And I think you tend to lose that if you are allowing the utilities to negotiate PPAs one by one. And so I do think OREC process overall makes more sense than a series of power purchase agreements, if I had to pick one or the other.
Okay, well, I figured since you're here applying for ORECs that
Yeah.
you would probably answer the question that way. But again, it doesn't seem that there have been a lot of success yet in actually seeing wind turbines spinning with ORECs. And as far as just as the markets have developed, I mean, I think Commissioner Sussman just mentioned the fact that we have a resource adequacy issues now, and there are a lot of stresses on the capacity market because of lack of those resources. Are we getting to a point where we still need to have the state policies as far as driving this, or do you see with the demand, particularly with the data centers and their desire for clean, non-emitting energy, that the states might be just getting in the way at this point, and are there better business models at this point to try to negotiate these power purchase agreements you need?
Yeah. I do think that is an emerging topic that we, from my perspective, I'd like to see the market develop a bit more to see how long-lasting the data center boom, AI boom is. Is it long enough lasting that it really can support infrastructure, which is very different? When we build infrastructure like a power plant, we're assuming it's going to be around for 30 or 35 years, and we're investing all the money up front so that it lasts for 35 years. The data center boom is a pretty new thing, and so I think I'd like to see it have some more time to develop to see whether it really does match long term with a new build project. So I think overall, it's good to have more buyers for power if you're a power seller, right? It's a good thing that there's more demand from my perspective. I don't think that demand is mature enough yet that an offshore wind project could rely on it quite yet. That might be different in 3 or 4 or 5 years.
Okay. And then finally, just a little bit of discussion again about PJM, and I want to talk more about just the transmission planning.
Sure.
And the fact that we really haven't at this point, received a lot of support from PJM as far as, where are we going with our transmission system. For the Marwin project, I'm guessing you're pretty confident in the pricing of what, the ISA is going to require of
Yes.
you, and you believe that the Indian River site is going to be large enough, it's going to be able to bring on shore I guess the first 409 megawatt nameplate capacity. Is that correct?
That's right, and that is why there is a timing difference between Marwin as phase 1 and the other 3 phases, because Marwin has this more advanced interconnect agreement, number 1. Number 2, the amount of capacity that first phase has, a little over 400 megawatts, does not require a whole lot of network upgrades in order to interconnect that into the PJM system. So this timing difference between the phases is our attempt to get power on sooner. So one phase we can get on quickly, relatively quickly, in offshore wind industry. 2028 is quick. That first 400 doesn't need a whole lot of network upgrades to interconnect it. The next 1,300 does require substantial network upgrades.
Okay, and that for, do you see being able to bring all 1,700 megawatts or the other 13 through that Indian River site, or is that about at capacity at that?
Yeah, that is definitely our plan. We think that's the best interconnection point anywhere on the Delmarva Peninsula or near the peninsula. I guess theoretically you could inject as much power as you want somewhere as long as you had enough money to do the upgrades, right, theoretically. We have studied pretty extensively the amount of upgrades that would be necessary to interconnect that incremental 1,300 megawatts. And so our application includes our estimate of that, and I feel pretty good about it. But as you know, ultimately PJM will decide the timing and the cost level there, and we're responsible for paying it. We've done a lot of studying. It is one of the big sort of questions for offshore wind, broadly speaking, on the East Coast, finding good places to interconnect, which is a combination of the network upgrades, but also being able to get the land rights to land your cables and that sort of thing. It's a critical project element. It's why we're so happy about our location at Indian River. There are very few sort of coal plants remaining that are likely to retire where you have a relatively easy interconnect. They're few and far between. You can't really make them up again. So that's a really important part of our strategy.
Okay, so when we're looking at the other 3 phases, you feel like you have a good handle on
Yes,
what
sir.
you believe those costs are going to be, and you've factored that into this estimate.
Yes, sir.
Even though there's
There are
some
very material.
uncertainty at
There are
PJM.
material costs associated with it, and those are included in our application. Yeah.
Okay, yeah, because that's, I guess, again, we're still looking to PJM as what they're going to do with the interconnection process, moving forward. And so I just wanted to,
Yeah.
just to hear you say that, yeah, you feel like you have priced in what you believe it's going to cost, even though there is some uncertainty with PJM at this point.
Yes, sir. We've done our best estimate for all of that.
Okay, terrific. Well, thank you.
Thank you.
Thank you, Mr. Chair.
Commissioner Barbe. Thank you, Mr. Chairman. No questions. Thank you for your testimony. Oh, what's that?
Yeah. Well, actually, you go ahead and then I'll finish.
Okay, so actually, I just have a follow-up, perhaps to Commissioner Richard's question, or maybe my own. So I had assumed that you would just be participating in the energy market. So talk to me about your anticipated participation in the capacity market. So you're looking at a capacity factor of 40.
46 to 47%,
Okay.
depending on the phase.
Right, and is that sort of known? So can you know in advance when you're expecting to be able to generate electricity?
So PJM has a set of rules that regulate capacity from wind.
Okay.
And so they will assign initially a capacity credit, which I believe Mr. Repsher, who's our witness, certainly can speak of this in detail. My recollection is somewhere around 30 or 35% capacity factor is what they assume up front. And then as we actually have production experience, we expect that we would get some additional credit as we actually generate more.
Okay. All right, thank you.
Yep.
Interesting.
Okay, so your discussions with Mr. Fields, you talked about the need for some flexibility when it comes to setting up these contracts for various pieces of the process. So what parts of the installation are coming from Europe?
Well, I would say we are not quite at the stage where we know precisely. It's a little easier to talk about what's not coming.
Okay.
So as you know, the Sparrows Point facility is an important part of our plan here in Maryland. We expect to be producing the steel foundations at Sparrows Point. So using steel coming from a steel mill in the United States, steel slabs get shipped to Sparrows Point. They get rolled, they're welded together, they're painted and coated and all that sort of thing. So the foundations, that is sort of our base case plan, certainly for phases 2, 3, and 4, to make the foundations at Sparrows Point. We also, as you know, have proposed this investment in the Hellenic Cable facility. So we expect cable to be coming from Maryland. As much of it as we can. There are several types of cable involved. You have 66 kV cable that are called inter-array that connect the turbines to the substation offshore. And then you've got a bigger transmission cable that takes the power from the offshore substation to the onshore substation. As Hellenic scales up over time, we hope to get all of the cable from that facility if we can, certainly as much as we can. The big factor that comes from Europe are, number one, right now, all the turbine factories are in Europe. So, including GE's facility in France. Whether several of them are at least thinking about facilities in the United States. So whether or not those turbine components come from a U.S. or European facility is not yet determined. The vessels, however, are a mixed combination of U.S. and European vessels. So the really large installation vessels are almost exclusively European, although there are several U.S. vessels being built today. And so we're talking to the owners of these new build vessels for the U.S. market, and there only are a few, but they're very important, as well as the European installation companies. But there will be a whole host of U.S. smaller vessels that we will be using, barges and tugs and things like that. So it's a mix. Right now, I would expect that ultimately the project will be a mix of components from the U.S. and from not the U.S.
So I guess what I was trying to get a better understanding is you talked about, the need to be flexible because of the competition, and there was competition from the existing European facilities since they're a lot farther ahead with us when it comes to offshore wind. But now there's, as you mentioned, there's a whole lot of other U.S. projects that are now sort of in the game. So how do you handle this competition of the new interest from states up and down the eastern seaboard?
This is the puzzle that we're putting together. And in reality, for the components and the vessels, it really isn't a U.S. competition. It is a global competition. So a large vessel can come to Maryland or can go to Taiwan. So it is truly a global supply chain here. It is one of the reasons why we wanted to domesticate in Maryland as much as we could within reason, and that's why the Sparrows Point facility is important. It's why the Hellenic Cable facility is important. Those are two important project components that we're anchor customers at, right? So we sort of take that risk off the table. The flexibility is critical when we're piecing these things together, because the more sort of rigidity there is to the project, whether it's through orders, not just pick on the PSC, or permitting restrictions, whatever it might be, the more rigidity there is in the project, the less able we are to put all the pieces together. Because we may have, for an offshore wind project, you can get 99 out of 100 things right, but you need 100 out of 100. So if you're signing up these contracts and there's one vessel left, and that last vessel is the last one you need, but the terms are really crazy, it will cause us to go back and rethink the project, to say, well, let's re-engineer something. Let's change the turbine size. Let's change the type of offshore vessel that we're going to use. Let's re-engineer things so that we're no longer constrained. So it is not, I guess what I'm trying to say is, it is a creative process that where both the commercial side and the contract negotiation and the engineering are constantly talking to each other about how do you piece everything together given all these market constraints. And so our initial plans and how we're going to piece it all together are very unlikely to be the final plans, right? We're going to use a different vessel. We're going to have a different kind of design for a foundation. And that's kind of a natural part of the process. That's how you, I guess some people call it value engineering. That's how you sort of maintain your ability to control your project costs and schedule by having flexibility.
So you mentioned a number of times the economic development opportunities that you're doing in the Baltimore region, but where else in the state are you making significant investments that have economic development?
Well, we certainly would like to make some investments in the Ocean City area. We have proposed an operations and maintenance facility there, which obviously makes sense because it's on the coast. We have secured some land in the Ocean City harbor, and would like to build an operations and maintenance facility there that will create jobs for the long term. Obviously, as an offshore wind industry, we are very much focused on places where there's water. So the port facilities in the greater Baltimore area are critical components, both as far as Point Steel, the Atlantic facility. I would say there are lots of jobs that people don't typically think of that are associated with offshore wind, and folks that are spread around the state, whether they might be engineers and survey firms and, God forbid, lawyers and others like that. So there are quite a few white-collar jobs that are associated with this project, and that's why we're able to deliver the local content we can, because we're trying to maximize the amount of folks locally that we can use, and those folks could be anywhere in the state.
So, explain to me the pushback you've received from Ocean City about the proposed facility there. Is it
I
no
think
good deed goes on?
So you may be aware that Ocean City has very much threatened litigation against the project, and they in fact did file a suit on Friday
Yeah, and I understand
against the
their
federal
opposition to the project in
Yeah.
general, but I guess
Yeah.
I'm trying to get more focused on what's their particular problem with the facility you're proposing that's actually located in Ocean City, because it strikes me that jobs for them is something that they would like, but apparently they're not too. Now, is it just a stalking horse for the fact they don't like the thing in general, or is it more related to the specifics of that?
It's unclear to me what precisely is behind it. I presume that it's the larger concern with the project.
Sure, yeah. Okay. So you talked about this process where the turbines may be getting bigger, and I know since I've been involved in this, the technology is advancing, and so the turbine sizes are getting bigger, which is a good thing. But again, getting back to Ocean City, one of their concerns is how many of these things are going to be out there. How much trade-off is there between a bigger turbine and fewer turbines? I mean, is it significant, or is it not really that big of an issue?
Well, one thing to keep in mind, Chairman, is that the size of the turbines is now set as a maximum in federal permits.
Okay.
So we cannot exceed the size that is now in our federal permits, which are, that process is nearly complete. So there is a maximum that's knowable, and we may pick a turbine that is at that limit or something a little smaller. So, but it won't be larger than that limit. If larger turbines are important to bringing costs down these projects, right? Because we can produce more power for every location. We have a limited number of locations in the wind energy area. In our application, we propose 114 turbines. We think that's the maximum we can set out there. We know that Maryland has an 8,500 megawatt offshore wind goal. So we try to produce as much of that as we can within our wind energy area. Larger turbines mean that in the same lease area you can get more capacity. And so we're always trying to get the maximum amount of energy that we can out of the wind farm, because it helps bring costs down, and frankly it helps meet everyone's goal, and we all know that the state is starved for capacity.
So regarding the federal permitting process, since the federal government at a sort of top level has been, hot and cold on offshore wind since we got started in this back in 2013, I mean, is your permit to a spec where you're essentially assured that you're going to go ahead and there won't be any more holdups with them?
Well,
I understand
what I can tell you is we will have all of our federal permits in hand. I believe the latest date is January 4th.
Okay.
The main permit from BOEM will be the COP approval, which is scheduled for December 3rd, and we have every expectation they've been really on schedule. I expect to have all federal approvals in hand by that last date on our schedule, which I believe is the 4th of January. It's quite important to have those permits in place as quickly as possible. I think there is a good history in the United States of permits, even in offshore wind, withstanding court challenge and otherwise. We're very confident that the federal agencies have done an extremely thorough job and feel that those permits are very strong and will withstand scrutiny from anyone who looks into them. You may recall that we submitted our permit applications in 2020, and so it was a 4-year cycle for the agencies to review our permits, a little over 4 years. Prior to that 4 years, we spent years collecting the data. So in all, it was far more than 4 years, the permitting process. So we feel very confident there, and I think we are taking every step that we can take to make our permits as durable as possible.
Okay, and then, so I'm pretty familiar with the BOEM process from previous jobs, but explain to me this Bessie process.
Yeah. So you may recall the disaster in the Gulf of Mexico when the Deepwater Horizon disaster.
Oh, okay.
So after the Deepwater Horizon disaster, the agency that governed that offshore oil and gas production, which was also the agency that governed offshore wind, because that agency, which was called the Minerals Management Service, issued all the leases. You must remember MMS,
Okay,
right?
I remember that, yeah.
After the Deepwater Horizon, Congress and the administration did big review regulatorily. They took the agency, they split it in two. And they said BOEM, Bureau of Ocean Energy Management, has essentially the front end of the process. They issue the leases for not just offshore wind, but offshore oil and gas.
Right.
They do the development, they do the permitting, the leasing. When you get to the point of construction, their sister agency, the other agency that was split from the old MMS, Bessie, Safety and Environmental Enforcement, takes over. They are essentially, think of them as the federal government's engineer. So their role is to ensure that we are building according to standards. So they are involved in essentially every aspect of the construction of the project. So they will hire an independent third party to an engineering firm, essentially to visit all of the sites where our components of the wind farm are being made, to verify all of the records, all the production, manufacturing records. They will confirm that the turbine is type certified and has certifications from different agencies. They will have inspectors out of the construction site when we're installing offshore and onshore. And they will do extensive document reviews to make sure that all of the construction activities are done according to standards that they've set. Bessie has a lot of experience because of the offshore oil and gas industry that they've regulated for many, many years. So they are essentially the federal government's engineer to ensure that we are complying with appropriate standards during construction and operations.
Okay, but they don't do the environmental stuff that
They don't. BOEM does that up front, right?
Okay.
Exactly. And Bessie is
They just want to make sure your thing's not going to fall down once it's
that's right.
built.
Yeah.
So, okay.
Yeah. I want to make sure of that as well. So.
Yeah, I understand. Last question. So on page 11 of your direct testimony,
Yep.
you mentioned the MBE participation.
Yes.
And what's the MBE goal that you have for this?
15% of our in-state expenditures.
Okay. Now, I'm aware of the fact that some other parties have suggested that maybe we increase that.
Right.
And obviously the states, had a pretty strong commitment in that field. And this commission has been involved in doing this when it comes to the public utilities and pushing them to do more of this. So I guess I want to hear from you, how much room do we have if we are interested in trying to up that?
Yeah. I would say we have spent quite a bit of time on our MBE plan, and we have a full-time staffer from the Baltimore area who helps us develop local companies to participate in the offshore wind industry. So we're very committed to our MBE goals. My reaction to the suggestion, there were several suggestions that were all interlocking in MBE, is that, again, to the extent we impose hard conditions on the project, we are increasing the level of complexity and increasing the risks of problems with the project. This is a very new industry in the United States. There are entire parts of our supply chain that simply don't exist, not only in Maryland, but in the United States. So as I look through our project expenditures, there are only certain areas that can be local content, that can come locally, and we're trying to maximize those as much as we can. But I don't want to set us up for a goal that I know up front is not achievable. So I believe, have, I forget the term, it's good faith efforts or something to that effect to meet the MBE goal. I am certainly open to a stretch goal. What does concern me is if the stretch goal becomes, if there's a financial penalty associated with it, and I know it's a stretch goal, and I know that I'm going to get penalized if I don't hit it, that is translated into a project cost to me. If I know I can't meet it, but I'm going to get penalized when I don't meet it, I'm just going to consider it a project penalty.
Excuse me, Mr. Chairman, what is a stretch goal?
Yeah, well, I'm trying to show some flexibility here. We have a 15% commitment on MBEs. I think that is not an easy one to meet, but I believe we can meet it. If you were to say, can you try to meet something higher? I'm certainly open to trying to push the boundaries. And I feel that we are quite committed to the MBE goal, and I think we take it very seriously as a company. And so I think my obligation to comply with the good faith efforts to do it, I take very seriously. So I am certainly open to a higher goal, but I really caution that to the extent there are financial penalties associated with not meeting that quote, those goals, that really becomes quite difficult for us.
So let me ask you, is that the type of item that the banks are going to look at as a part of the risk?
Yes, sir, they will.
Okay.
They will. They will go. I can assure you that the banks are intimately familiar with the OREC order. They know every clause of every paragraph, and we debate with them over what semicolons mean. So your drafting of those orders is quite important to us, and that's why we've made certain requests. So they will look at the MBE goal and they'll say, okay, Jeff, you've just told me that getting from 15 to 17% is really hard, and you've got this financial penalty. We're just going to assume that you're never going to make that. So, you're out of compliance. So that's the kind of thing, Chairman, that we try to avoid, is setting unrealistic expectations that have penalties associated with them.
Okay. Fair enough. Anything else? Okay, thank you very much.
Thank you, sir. Thank you, everyone. Bye-bye.
Mr. Chairman, could I have this brief redirect?
Oh, yeah, I forgot about that. Yeah, so stay put. Yeah, so, yeah. Yes. Go right ahead.
Thank you, Mr. Chairman. Just a couple of brief questions, points of clarification. Mr. Grabowski, you recall the discussion you had with Commissioner Suchman on the investment tax credit and the production tax credit?
Yes.
Just for the benefit of the record, I wonder if, and to avoid having to close the session because of confidentiality reasons, I wonder if I could just pinpoint the portion of your testimony and the section of the application where we provide this information. And specifically, it would be U.S. Wind's financial model assumes that the project will receive the federal investment tax credit at a certain percentage level. And would you agree that's in section 4.5 of the application and on page 15 of your direct testimony?
Yes.
Thank you. The chairman mentioned the MBE participation goal of the project and what sort of change or flexibility could there be. If the local utilities here are in fact reporting on an annual basis to the commission that they are achieving more than 15%, 20, 25, 30, and beyond in terms of their MBE participation, could you just talk a little bit more about how the supply chains of the local utilities here in Maryland differ from the supply chains in the offshore wind industry?
Yeah, sure. Obviously, local utilities have been in operation for many, many, many decades and have had the opportunity over 100 or more years to develop a supply chain that's very focused on what they do every day. That supply chain has a small overlap with what we do, but we're really not in the same business. So we have one onshore substation, which is the thing that's most comparable to what they do, which represents a pretty small percentage of our project costs. The overwhelming majority of our project costs have essentially no overlap at all with local utilities.
Thank you. No further questions. Thank you, Mr. Chairman.
Okay, thank you very much.
Thank you.
Mr. Chairman, we have a next witness, if the commission is ready.
Sure.
Would ask Ms. Laurie Jodzowitz to come to the stand, please, and Mr. Previs will introduce her testimony.
Good morning, Mr. Jodzowitz.
Good morning.
Would you please state your name, employer, and business address for the record?
Certainly. My name is Laurie Jodzowitz, and that's Laurie. Last name is Jodziewiczz. I'm the Vice President for Environmental Affairs at U.S. Wind, and our business address is 401 East Pratt Street, Baltimore, Maryland.
Thought about that. Hey, and I missed this on the first guy, but do we need to? So,
Mr. Chairman, we did swear in the first witness,
Oh, okay.
Mr. Grabowski, and the court reporter did do that. We're certainly prepared to have that repeat,
okay. So,
if the court reporter would like.
yeah. So, okay.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Certainly. My first name is Lori, Laurie. My last name is Jozowitz, Jodziewiczz. And our business address is 401 East Pratt Street, Baltimore, Maryland.
Thank you, Ms. Jazowitz. What is your title or position at U.S. Wind?
Sure. I'm the Vice President of Environmental Affairs.
Do you have before you your written direct testimony in this case consisting of 17 pages dated September 6th, 2024?
Yes, I do.
What number are we on? 9. Is it 9? 7. Do you have before you your written rebuttal testimony in this case consisting of 9 pages dated October 21st, 2024?
Yes, I do.
Was this written testimony prepared by you or under your supervision?
Yes, it was.
Do you have any corrections, changes, or updates to your written testimony?
No.
Is the content of your written testimony true and accurate to the best of your knowledge, information, and belief?
Yes, it is.
Would your answers in this written testimony be the same today as when you wrote them?
Yes, they would be the same.
Mr. Chairman, I ask that the direct testimony of Laurie Josowitz be marked as U.S. Wind Exhibit Number 7,
So marked.
and if there are no objections, moved into the record.
So admitted.
I will also add just that there is no confidential version of any of Ms. Josowitz's testimony. Mr. Chairman, I also ask that the rebuttal testimony of Ms. Josowitz be marked as U.S. Wind Exhibit Number 8, and if there are no objections, moved into the record.
So marked. So admitted.
Mr. Chairman, I have brief rejoinder for this witness. Ms. Josowitz, can you please summarize for the Commission U.S. Wind's permitting progress since the last OREC proceeding, based on your prior testimony and the rebuttal testimony?
Certainly, we've made significant progress in our permitting work for the entire offshore wind project in the lease area. That's primarily been through the submittal of applications for all of our federal and major state permits, and really recently culminated in the final environmental impact statement from the Bureau of Ocean Energy Management, or BOEM, as I'll refer to them. That was also signed on to by the National Marine Fisheries Service. And that was to advance our project and our construction and operations plan that we had submitted back to BOEM in August of 2020. And so with the record of decision issued in September of 2024, that was a significant milestone for our project. We also have, as Mr. Grabowski mentioned, we have some other federal permits that we expect to be coming into our hands over the next few months, including the construction and operations plan approval, as well as our Army Corps of Engineers permits and our final incidental take authorization from the National Marine Fisheries Service. One of the things that we did with all of those permit applications, and specifically with the construction and operations plan, is to take the opportunity to incorporate the conditions that we saw in the OREC order back in 2021. And so we incorporated conditions such as the inclusion of the aircraft detection lighting system. We included a lot of the marine mammal protection order conditions as well. And we included those as applicant proposed measures in our construction and operations plan, specifically so that the agencies that are involved in those, for example, BOEM, as well as the National Marine Fisheries Service, could review those conditions, and then they are now considered incorporated into our project, and we will be required to comply with those. So once we put those mitigation measures as applicant proposed mitigation measures in our construction and operations plan, if you take a look at the record of decision that was issued in early September, those all of those mitigation measures, so everything that we had included from the OREC conditions, are now going to be required for us to move forward with construction.
Thank you. This witness is now available for cross-examination and other questions.
Okay, Sierra Club,
No questions.
Earth Justice,
No questions.
DNR. No questions. OPC,
No questions either.
staff.
Yes, just one question. Good morning, Ms. Jazowitz.
Good morning.
Do you have with you a copy of staff data request number 5?
Yes, let me just check. I believe I do.
And I have copies I can distribute to everybody.
Well, that might speed things up, actually, so go ahead.
Yes, I do have a copy of that.
All right, what you...
Thank you.
Okay. Can you confirm that these responses were made by you?
Yes, I can. They were.
Okay, wonderful. This time, I would like to mark this as Staff Exhibit 1, and if there are no objections, admit this into evidence.
May I make request a quick clarification? I just want to reflect for the record that what was handed out is actually request set number 5, which consists of 2 questions, and it's a front and back document consisting of 5.1 on the front and 5.2 on the back. With that clarification, we have no objections.
Thank you for that.
Okay. So marked, so admitted.
And thank you. No further questions.
Okay, any redirect?
No redirect. Thank you, Your Honor.
Commissioner Richards.
Yes.
Good morning. Just one question. I'm just interested to know about the state of the I guess the FAA requirements for the I guess airspace obstructions. There was discussed even back in I guess 2017, 2018 when we had these hearings about an interest in at night, particularly not having the constant flashing lights. With some of the projects that have gone in already on the East Coast, does that technology exist that turn the lights off unless a aircraft is approaching?
Yes, and that is one of the conditions from our OREC order in 2021 that we did incorporate into our construction and operations plan. And we did have to say in that time, whether commercially and technically feasible. And the FAA does now include the aircraft detection lighting systems as parts of its, and I don't recall the number, but in its advisory circular as an allowable technology.
Okay.
And so we do see that the other offshore wind farms have implemented that, and that is a pretty standard requirement at this time for having those aircraft detection lighting systems. When we did our evaluation, we found that would reduce the lighting about 99% of the time, so only about 6 hours of a year would the actual red flashing lights be on.
Okay, great. Well, thank you very much. I appreciate that answer. Thank you, Mr. Chair.
Commissioner Barbe.
No questions. Thank you, Mr. Chairman.
Commissioner Gillespie.
Good morning. So I'm going to ask you a question that maybe you can't answer, but perhaps somebody at US Wind can. So we had mentioned earlier, or your CEO had mentioned that that Ocean City has sued BOEM. If Ocean City is successful at some point after construction has already begun, what's there in place for removal of what's already been deployed, and is there something in the contracts dealing with the cost responsibilities?
So let me just maybe break that down in a couple of ways. So I'm not an attorney, so I can't necessarily speak to the the validity of any lawsuit or anything like that.
Yeah, no, I'm not.
Okay.
And please don't
Okay.
go into that. Right.
Yeah.
Right. This is mostly about responsibility for taking down the turbines that have already been sort of
Absolutely.
deployed, and who's responsible. And I guess to the extent that there are if there are bonds or something in place, where would that be in the contract?
Well, those are requirements under the regulations with BOEM. So for anything that we put out onto the outer continental shelf, we are required to decommission that.
Okay.
And so that includes everything basically 15 feet below the mud line, as they call it, unless you're approved to leave something in place. For example, if it was more environmentally damaging to remove cables and just instead leave those in place, that would be allowed. But that decision has to be made once you submit your decommissioning plan. The financial obligations for that decommissioning do come as part of our lease, and so we are required to put in place some kind of financial assurance for the decommissioning of all of the infrastructure offshore.
Okay. And is that in place now? The financial aspects, or that will be in place once construction begins?
That's correct. So we did have a decommissioning bond for the Med Ocean buoy that we had out. So it could give us a good practice run.
Okay.
We had to have that in place for removal of the buoy should we not be not around any longer. And so that is standard practice. For the larger decommissioning bond for the overall project, that comes into place closer to construction.
Okay. And do you have a sense of how large that bond is?
I can't answer that for sure. So that probably is a good question for Mr. Filippelli or potentially for Mr. Repsher about how that was included in the financial model. I can say that a lot of that infrastructure can be recycled or has scrap metal value or things like that. So. But we don't have that. I don't have that.
I think the most
estimate
important concern for me is that somehow Maryland ratepayers are not footing the bill for that. So that I just want to make sure that there's sufficient resources in place that to the extent that something were to happen after you already begin construction, that you've got the resources to be able to take down whatever has been put up.
Yeah, and so I can say that because that is a regulatory obligation, and so that has been worked into the financial model.
Okay, great. Thank you.
So on page 6 of your direct testimony, you talk about U.S. Wind consulting with the Department of Defense and the maritime community. And I'm assuming this has to do with ships, going near the turbines. Now, if I remember right, not only was it the U.S. Navy and the fishermen, but there's actually the transatlantic freighters, and there's lots of traffic up and down the eastern seaboard. So were you involved in that whole process and trying to sort all that out about who gets to go where?
Yeah, certainly not just me personally, but our entire team. And so there's been a number of conversations both along the East Coast and in our project area specifically. So at one point, the traffic separation scheme, which are the shipping lanes coming into and out of Delaware Bay, in our case, it's the kind of southern approach and exit. At one point, that just stopped at our kind of midway through our lease area to our east, and so a lot of traffic would go down the shipping lane and then just head straight south. Which would have been right through our lease area. And so we did work with the Coast Guard, as well as this overall plan for the port access route study and other regulations where they've kind of defined where the shipping traffic can go around offshore wind areas because they have been established. And so in our case, the traffic separation scheme has actually been proposed to be elongated so that it would go all the way down to the east, all the way down our eastern side of our lease area, and then stop at the end of that, kind of to the southeast. And so all of the major shipping traffic would be directed around the offshore wind farm in a designated traffic separation scheme. And I would say that other ships, because of the way that we have the spacing and have allowed for navigation, our spacing is about 1 nautical mile, a little over 1 nautical mile north-south, because we do see a lot of fishing vessels, recreational vessels, and so we provided significant room to allow them to continue to transit and use the lease area. But certainly the shipping traffic has been now routed around it.
And I guess given that, we're not going to have absent, something extraordinary, we're not going to have a similar episode with one of your turbines that we had with the bridge.
Certainly not. We have a 1 nautical mile setback from the traffic separation scheme, so that's not required. It was another one of the mitigation measures that we proposed. You'll see in our construction and operations plan, for example, we had a maximum number of 121 turbine locations. We removed 7 of those along that eastern edge to allow for a 1 nautical mile setback from that traffic separation scheme, and that has been reviewed by the Coast Guard and BOEM and Bessie, as was described. So that has been seen as sufficient, and then we also have a navigation safety risk assessment that was part of our BOEM process that we put together for that.
Okay, sounds good. Thank you very much.
May I have a quick brief
Sure.
redirect, Your Honor?
Oh, yeah, go ahead.
I just wanted to ask if Ms. Jozowitz would elaborate very briefly on specifically the discussions with the Department of Defense and the military, because her answer went more towards the civil side. Thank you.
Sure. And so as part of the BOEM process, we also interact with the Department of Defense primarily through the siting counts, let me think of the name, the siting council that the Department of Defense has set up. So we twice submitted our project as well as all of our infrastructure to that for their review. So they review the cable locations, they review all the wind turbine locations, and then they also consult with BOEM through the BOEM process to determine whether or not there's any mitigation requirements or things like that. I will say that we have also submitted and received determinations of no hazard from the Federal Aviation Administration, and the Department of Defense does have a role in reviewing those. And so while we don't necessarily engage directly with the Department of Defense, except for that through that siting council, they have been quite active in the review of our project.
Thank you. No further questions.
Okay, thank you very much.
Mr. Chairman, Sunu Pillai on behalf of US Wind. If the commission is ready, we are willing to call the next witness.
Yes, go ahead.
We'll be calling Matt Filippelli.
Raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, tell your first and last name, and give us your business address.
My name is Matthew, Matthew. Last name is Filippelli, Filippelli.
Thank you.
And I am Vice President and Chief Engineer with US Wind. The business address is 401 East Pratt Street in Baltimore, Maryland.
Mr. Filippelli, do you have before you your written direct testimony in this case dated September 6, 2024, consisting of 24 pages?
I do.
Was this written testimony prepared by you or under your supervision?
Yes, it was.
Do you have any corrections, changes, or updates to your written testimony?
I do not.
Is the content of your written testimony true and accurate to the best of your knowledge, information, and belief?
It is.
Would your answers in this written testimony be the same today as when you wrote them?
The only change was my title At the time, I was Senior Director, Technical Development. I am now Vice President and Chief Engineer.
Mr. Chairman, I ask that the public version of the direct testimony of Mr. Filippelli be marked as U.S. Wind Exhibit number 9,
So
and
marked.
and the confidential version of the direct testimony be marked as U.S. Wind Exhibit number 9C.
So marked.
And if there are no objections, move to the record.
So admitted.
The witness is now available for cross-examination and any other questions.
So Sierra Club,
No questions.
Earth Justice,
LCB has no questions.
DNR, OPC,
No questions.
staff.
Good morning, Mr. Filippelli.
Good morning.
I'm Michael Dean on behalf of staff, and I'll have a few questions which I'll provide through data request responses. And as a preliminary matter, do you have a copy of staff data requests number 3 and 4 with you?
I believe so. Yes. I'll take it. Okay. Thank you. Thank you.
Thank you.
Were you the author or information provided to you of the responses to staff data requests 3 and 4?
I was.
Do you have any changes to the responses that you provided to these?
Not at this time.
Chair, staff would like to mark the first document, which consists of confidential responses to staff data requests number 3-3 A and B as staff exhibit number 2. C.
So marked.
The second document that was passed out consists of the responses to staff data request number 3-4, 3-5, and 3-6, and I'd like to mark that as staff exhibit number 3.
So marked.
And the last document consists of responses to staff data request number 4-1, sections A through G, and I'd like to mark that as staff exhibit number 4.
So marked.
And I'd like to move that staff exhibits number 2C, 3, and 4 be entered into the administrative record.
No objections.
So admitted.
And that constitutes staff's cross-examination of the witness.
Okay. Commissioner Barvey.
No questions.
Commissioner Sushman.
Good morning. I'm assuming you were here when I asked your colleague, whose name, let's see if I can, I'm not even going to try. But people mess up my last name also, so I'm in good company. I was asking her about the decommissioning plan and the bond. Are you familiar with it?
Yes, that process still requires some negotiation with Bureau of Ocean Energy Management, but yes, I am familiar with it.
Okay. So at this point now, you don't have a number. You're still speaking with BOEM about the size of the bond, but the size will reflect the obligation that you would incur to the extent that the project were to fail for whatever reason, and you would have
Or even just reach the end of life, that's correct.
Okay. So the bond is in place for whatever happens along the path. So something could fail before the project is put into service, or reaches the end of its useful life and has to come down. Okay.
Yes.
And is included in the bond any sort of catastrophic events that could happen? A hurricane that can send towers down, or is that covered by some other aspect of, sort of insurance or something else?
As it's currently envisioned, the bond is structured around end-of-life removal of the components. We anticipate getting a robust insurance package and coverages for those other types of natural disasters, storms, that type of thing, and that's typically what's put in place to repair or replace components that are damaged throughout the life of the project.
Okay, thank you.
Okay, Commissioner Richard.
Yeah, thank you. Good morning,
Good morning.
and just probably a similar question to what you just heard, but I don't know if you had a chance to listen to any of the public hearing we held the other night, and some of the issues that people raised. Did you have a chance to hear
I
any
did
of
not hear that
Okay.
session.
Well, there were a couple of people who brought up, and they were specifically very concerned about what happened at the Vineyard project, where I guess one of the blades, the very large blade, had a malfunction and broke, and I guess parts of it ended up on a couple of beaches, both in Nantucket and on Long Island. Is this anything you could add to today about, just to reassure people about the technology? Is this, is this something that we should be concerned about with the larger turbines, or was just as a one-off?
I would say that this is a very rare event, right? This is an uncommon and not to be expected circumstance. There's over 12,000 offshore wind turbines operating globally right now. In fact, that number's a bit dated, so it's probably closer to 15. One of the reasons that this is making so much news is because it's so uncommon. Ultimately, this is something that is unfortunate, but there are plans in place to manage this through emergency response plans that we have responsibility to develop, as well as modeling for understanding how issues like this can be both managed and where what communities it might impact. And so ultimately the blade in particular is, I would say, if you consider it similar to a boat construction, right? Laminated fiberglass and some foam, there was no oil spill. The consequence in this kind of event, while not trivial, is considerably lower than some other types of accidents that can happen across other offshore industries. And so, in general, we view the risk as very low. And this is a particular piece that BSEE is, as was discussed earlier, the Bureau of Safety and Environmental Enforcement is taking this incident very seriously. In fact, I think the most recent article had them saying is there's no real timeline for conclusion, and they'll take the amount of time required to ensure that the issue and root cause are assessed to the greatest ability of sort of their team and their third parties, so that they can modify the suspension of work if needed. So there is a significant amount of oversight in place now and protection for the environment and human safety in that case.
Great. No, I appreciate you're addressing that.
Certainly.
I think another aspect of that was raised is when something like this happens, who is responsible for the cleanup? Again, I don't know what the details were, but the way it was portrayed is there seemed to be some dispute as to who is ultimately responsible for cleaning up some of the, I guess, the debris from this accident. Can you just maybe just clarify from at least this project standpoint, should something go wrong, who would be responsible for cleanup?
Typically, it's the project sponsor, and that risk is then shared with its contractors or our contractors if it's our project. And so ultimately, under normal circumstances like that, under circumstances like that, it would be the responsibility of the project sponsor to clean up, and that responsibility is typically then shared with the major contractors depending upon what goes wrong.
Okay, good. So you can reassure some of those concerned citizens in Maryland, in Ocean City, that if something washes up on an Ocean City beach, your company and contractors would be responsible for taking care of any of those cleanup requirements.
Yes.
Great. Thank you. Thank you, Mr. Chair.
Oh, Commissioner Barbe.
Yeah, I hesitated to ask this question, but since you made an answer, did you just say that there are roughly 12,000 offshore wind turbines in operation globally? The reason I ask, the question I have is that typically my friends who oppose offshore wind will use this stock photograph of a burning offshore wind turbine, and I've tried to look on the internet for instances, and it seems to me from my uneducated research that there are only 3 or 4 such instances in offshore wind. You've been according to your testimony, you've been in this space for 20 years. Am I basically correct that it's a nearly negligible occurrence?
Statistically, yes. The reason it makes so much news is because it's happened so infrequently.
Okay, thank you, Mr. Chairman.
Okay, so the project proposed for here is going to be built on top of a piling, I guess, for one of the
Monopile
right,
foundation, yes.
And I mean, when we started this, that was originally proposed because that was the way it was done back in those days, but also because of the continental shelf that made it sort of advantageous. But I know that there's now been sort of advances in turbine technology, and now we have floating turbines. Has there been any consideration of moving? Is there any reason to consider that as an option, or is still the monopile the best approach to this?
The monopile is still the best approach for our site. It's the most economically attractive. It's the most feasible for the site conditions. It's also gives us the greatest amount of flexibility in our chosen contractors and allows us to, in fact, support Maryland with as much economic development as possible, because that type of foundation is well suited for manufacturing at Sparrows Point.
Okay. All right. Good enough. Thank you very much.
Certainly.
A brief redirect,
Yes.
Mr. Chairman. In response to Commissioner Barbe's question regarding the number of wind turbines, offshore wind turbines globally, you did not give a verbal answer, so I just want to confirm. I think you mentioned earlier that there are 12,000 to 15,000 offshore wind turbines in existence at this time. Is that fair?
That is my understanding, yes.
Thank you. Nothing further.
Okay. Thank you very much.
Mr. Chairman, just a procedural question for the commission, if I may. In our proposed schedule of witnesses, we had proposed the 3 witnesses who've appeared today as our first day of witnesses for Monday. We can certainly make Mr. Repsher available if the commission wanted to continue on with beginning our Tuesday witnesses today. If we did that, I might request either a short break or maybe we break for lunch, and then we could come back and we could put Mr. Repsher on the stand if the commission would like to proceed with Tuesday witnesses on today.
Okay, so with that, I mean, is everybody else, Mr. Fields?
Your Honor, our preference would be to pick up with Mr. Repsher tomorrow morning. Mr. Chang is en route right now. I don't think he's going to be available this afternoon. Like I said, that would be our preference to complete our preparation. We could, if it was the Commission's desire to move on with him this afternoon, we would ask for a healthy lunch break in order to finalize that. But like I said, our preference would be to do it tomorrow morning.
We've been actually zooming along here, so.
You decide, but that's, you could do that.
You have any thoughts on this?
Yeah, that's kind of.
I don't want to disadvantage the parties.
All right, so, I mean, if we came back at 2 o'clock, does that work for you, or if we?
Yeah, we could manage that.
All right, so we'll take a lunch break until 2 o'clock this afternoon, so.
Testing, testing.
Okay, back on the record in case 9666.
Good afternoon, Mr. Chairman. U.S. Wind would like to call, with your permission, like to call its next witness.
Yes, go ahead.
U.S. Wind calls Mark. For the record, this is Tom Previs, Saul Ewing on behalf of U.S. Wind. U.S. Wind calls Mark Repsher, R-E-P-S-H-E-R, to the stand.
Okay, you wanna-
Please raise your right hand. You do solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Sure. My name is Mark Repsher, M-A-R-K, Repsher, R-E-P as in Paul, S-H-E-R. My business address is 1700 Lincoln Street, Suite 3500, Denver, Colorado.
Thank you. Mr. Repsher, what's the name of your firm?
PA Consulting Group.
What's your title?
I'm a member of PA's management group.
And what were you hired to do in this particular case?
Yeah, I was retained by U.S. Wind with my team to analyze the proposed U.S. Wind bid prices relative to the various ratepayer tests that are applicable during what were previously called the Round 1 and Round 2 proceedings, as well as analyze the broader economic impacts of the proposed facilities on the Maryland economy.
Did you provide a report on those matters, which was included with the appendix of U.S. Wind's application?
Yes, I did.
Did you also prepare direct testimony in this case?
Yes, I did.
Do you have before you your written direct testimony consisting of 45 pages? It also consisted of your CV, which was at the end, dated September 6th, 2024.
I do.
Do you also have before you your written rebuttal testimony in this case, consisting of 17 pages, dated October 21st, 2024?
I do.
Do you also have before you your written direct testimony that was designated attorney's eyes only, also 45 pages, with your CV, which was also dated September 6, 2024?
I do.
Was this written testimony prepared by you or under your supervision?
It was.
Do you have any corrections, changes, or updates to your written testimony?
There is one correction I'd like to make to my rebuttal testimony, assuming that was part of that question.
Yes, any of your testimony.
Yeah, I would. There is one typo that I would like to correct. If I could turn everyone's attention to page 12 of my rebuttal testimony, specifically line 218. There's a typo, and I'll read the whole answer so it makes sense to people, but where it says 27%, that's a typo that should say 47%. Just to kind of read it in so people understand this number. So the question was, turning to Mr. Chang's assertion that PA Consulting should use a 3-year phase-in of price impacts to align with standard offer service SOS contracts, do you agree with this criticism? No, a 3-year phase-in is not consistent with any methodology used by the Commission in the Round 1 or Round 2 proceeding. In addition, only a portion of Maryland's ratepayers are served under SOS contracts. For example, approximately 50% of BG&E customers and 47% of PEPCO customers are served under SOS. The remainder of customers are served by competitive retail choice providers.
Okay, thank you, Mr. Repsher. Do you have any other changes, updates, or corrections to your written testimony?
I do not.
Is the content, with that change, is the content of your written testimony true and accurate to the best of your knowledge, information, and belief?
Yes, it is.
And with that change, would your answers in this written testimony be the same today as when you wrote them?
They would.
I ask the direct testimony of Mark Repsher be marked as U.S. Wind Exhibit 10, and that the attorney's eyes only version of the same direct testimony be marked as a U.S. Wind Exhibit 10C.
Marked.
And I further ask that the rebuttal testimony of Mark Repsher be marked as U.S. Wind Exhibit 11. And if there are no objections, I ask that both be moved, that all 3 of those testimonies be moved into the record.
So admitted.
Thank you. Mr. Chairman, I have a brief rejoinder for this witness, if I may. Mr. Repsher, after you filed your rebuttal testimony, ICF provided the ratepayer impact backup calculations to its evaluation report that had been previously provided, which ICF prepared for the Maryland Public Service Commission. Have you had the opportunity to review that?
Yes, I have.
And what, if any, rejoinder testimony do you have based on the new information provided in those papers?
Yeah, I think there's really only two things just to go over very quickly. Firstly, it lays out the ratepayer tests in an identical fashion to the way that I did it with the team at PA Consulting. Specifically, the way to think about the ratepayer test is U.S. Wind has proposed a bid price, but the legislature within Maryland has, we'll call them round numbers, has basically said that residential impacts cannot be more than 90 cents a month in terms of increases, and for non-residential customers, they can't be more than 1.5% of an increase. So the ICF test showed that that the U.S. Winds passed that test. When you account for the gross costs of the ORECs, minus the reduction expected in energy prices, and then minus the revenues that will accrue to ratepayers from the energy and capacity and ancillary sales from the facility.
Are there any nuances pointed out in the ICF backup papers that you think are necessary to address at this time?
Yeah, I think it's probably because it's maybe obvious when you open up the spreadsheet if folks have. The way that ICF ran the test is they ran it under a 20-year time horizon and then a 30-year horizon. So to remind people, this OREC contract is proposed for 20 years. Under ICF's analysis, the project does fail, I think, the residential ratepayer test under the 20-year scenario. However, the 30-year scenario that they ran, which is ultimately what they used for the scoring criteria, shows the facility to pass. And to put that in context, this wind facility, as I believe Mr. Grabowski noted earlier today, is expected to run 35 years. So while Maryland ratepayers will be on the hook for these OREC costs for 20 years, the facility is expected to run another 15 years thereafter, where the same impacts on the market would still be accruing to Maryland ratepayers for that tail 15-year period.
In addition, Mr. Repsher, does the COD of the project enter into the 30-year analysis?
Yeah, I think as is noted in the OREC bid sheets, there is the possibility, although not anticipation, but possibility for delays in the COD, which would push that contract period out somewhat further in terms of the expiry date.
Mr. Repsher, do you have any additional rejoinder with respect to any new information that's come in recent days?
Not at this time, no.
Okay. We have no further questions, and this witness is available for cross-examination and any other questions. Thank you.
Okay, so one quick thing for the folks doing cross. If you think you're going to be entering into confidential territory, why don't you give us a heads up so we can turn off the TV camera. So. Sierra Club.
No questions from Sierra Club.
Earth Justice.
No questions.
DNR. No questions. OPC.
Good afternoon, Mr. Repsher. I'm Ryan Hsu with Office of People's Counsel.
Nice to meet you.
Nice to meet you. I guess I want to start with what you just mentioned. So the ICF, as you just said, the ICF ratepayer test failed on the 20-year, but then when they extended it to 30 years, it passed. What is the OREC pricing schedule timeline currently? It's 20 years, right?
Yeah, correct. So the two timelines differ slightly between the phases, but based on my recollection, because I get confused between December and January, but I think it's December 2028 through 20 years post that, and then the second phase would be, I believe, December 2030 or thereabouts, and for 20 years after that, correct?
Right. So essentially, the proposal is that the OREC prices and the OREC, essentially the surcharge that would be collecting the OREC costs would last for 20 years, right?
Correct.
Okay. When you mentioned the COD anticipates pushing things further out, what does COD stand for, first of all, and then what did you mean by that?
I might, so I'll answer the COD question, then I might have you repeat that question. I'm not sure I heard that.
Yeah.
So yeah, I'm sorry for throwing around acronyms. COD stands for Commercial Online Date, so effectively the date on which the facility would be electrically interconnected to the PJM grid.
Okay. And then I believe in your answer you mentioned something about that, like anticipating pushing things further out. That wouldn't be the extending the schedule. That would just be moving the 20 years to some later date if it doesn't come online immediately, right?
Yeah, and I apologize for the confusion. Yeah, all it would do is shift the 20 years out. Okay. So Maryland ratepayers, regardless of when the COD starts, would only be paying for the ORECs for a 20-year period.
Right. Okay. Yep. Thanks.
Yep.
Okay, so in calculating the ratepayer impact test, the basic idea is that you take the flat cost from the OREC schedule, and then you subtract any projected benefits in the forms of lower energy prices from the project, and then you essentially divide that amongst Maryland's projected load to come out with, what a monthly ratepayer impact is, right?
Correct, with one nuance. The other thing that, as I can't remember the witness now that we spoke about, it might have been Mr. Grabowski, the project will also be selling that energy and capacity and ancillaries into the PJM market. So those revenues accrue as, I guess, cost savings to Maryland ratepayers that then are, net off the gross cost of those. Yep.
Right, okay. And so that denominator, right, so this is a cost, the OREC cost is only borne by Maryland ratepayers, right?
Correct.
So really in that denominator, the only thing that goes into that is Maryland's projected load and, Maryland's projected load growth in there.
That is correct.
Okay, thank you. I have, I guess we're going to, so on page 12 of your rebuttal testimony, the lines you corrected in terms of the percentages, lines 216 to 219, where you state that approximately 50% of BG customers and I guess 47% of PEPCO customers are served by SOS. I guess I have something to hand out regarding that.
Sure. Thanks.
Thank you.
Oops, sorry. Good. So, Mr. Repsher, the document I just handed out is OPC DR 11-1, which essentially just asks for the source of that, statement regarding the percentages and the company's response therein, right? So, I guess so first off, looking at this response, it says that, he notes typographical error. It should say 47% of PEPCO customers are served under SOS. As determined by percent of load. So I guess it's really more not like percentage of customers, but percentage of load under.
Correct. I probably should have said that in the rebuttal, but it was by percent of load.
Correct. Okay. So and then the response cites at the bottom sort of and attached, which I attached to the back of this, the 5-year SOS report from January 5th, 2024.
Yep.
Correct. And then so if you turn to page 15.
Yeah, I'm there.
Yep. And then the table, is percentage of peak load served by competitive suppliers in November 2023. So in this table, you can see that the total for residential peak load served by suppliers at the bottom line there is 13.1%, right?
For residential customers, that is the number, yes.
Yeah, and then the total might be 41%.
Correct.
But yeah, the residential's at 13%, right? So essentially, about 87% of residential customers are served under SOS, at least as of November 2023, and
That is what the report says, yes, and I take it as true.
yeah, subject to check, I suppose. So, the SOS portfolio phases. Are you familiar with the SOS? How the SOS portfolio works, like generally?
Yeah, I'm happy to explain it to the commission if they want to hear about it. But yeah, happy to do that as well.
Sure. So essentially, the portfolio phases new contracts in gradually, about 25% each procurement cycle, correct?
That for residential customers, that is correct.
So then, when a new round of SOS contracts come in, that's only a portion of the overall portfolio. And so when the offshore wind projects come in and reduce energy prices, the effects of that would be felt on the new SOS contracts, but you'd still have much of the same SOS contracts that were before the offshore wind coming in, correct?
Yeah, although I'd like to explain if possible, or unless you have other questions. Yes, with nuances. So the way to think about this from a residential perspective, and I think firstly let's remember we're talking about both residential and non-residential customers here. So agree that for residential customers, every 6 months, 25% of load is procured for a 3-year period. So it is correct to say that sometimes it's called a laddering strategy, which is used really in many jurisdictions across the U.S. in a way to provide some sort of hedge, if you will, for ratepayers, that they're not, if gas prices are $100 tomorrow and that's when contracts are, going to get locked in, that all of a sudden there's this impact felt. Now for non-residential customers, I believe it's every 6 months, or it might be every 3 months, 100% of load is procured. So that is pretty consistent. So the thing to remember though is when we're talking about impacts to retail customers, whether we're talking about customers served under SOS contracts, so put another way, their default supplier or a competitive supplier. For those SOS retail customers, just because you are entering into a contract, let's say tomorrow, that doesn't mean that the only thing that those suppliers are thinking about is what are the costs today. They're having to, at the same time that they enter into a contract with those utilities, they're having to also enter into contracts with other parties to potentially contract for that generation, or they may be using their own generation. And just like we're doing forecasts here, those suppliers are also going to be looking on a forecast basis, what do they expect power prices to be, what do they expect load to be, et cetera. So while it is a point-time contract, just like the U.S. wind team here is saying, what do I need over a 20-year period, those retailers are saying, what do I need over this 3-year period that I'm going to be contracted for? So I would say that, regardless of when a contract starts, there is an anticipation of how that factors in. So yeah.
Okay. But you probably couldn't factor, the suppliers bidding into SOS probably couldn't factor the offshore wind in until they knew it was actually going to be there, or had some reasonable likelihood that it was going to be there, right?
I would say that so again, for residential, the furthest out you would be is 2 years from COD. At that point, if we're talking about an offshore wind project, the facility would be well under construction. There would be a pretty good view on whether or not it was going to happen. When we do our analyses at PA Consulting, it's what we'll call it a firm addition, when you're very sure it's going to come online because it's past certain milestones. So I would say that they would be anticipating that. I would also say it's very likely that the forward market, so forwards for power or gas, would also be reflecting what is generally anticipated in the market. So my belief is that they would be able to factor that into their prices for consumers.
Okay. So, Mr. Repsher, your analysis doesn't include a decay effect, correct?
No, the regression that we ran is identical in form and structure to the regression that was utilized during the round 2 proceedings in 2022, I think that was.
Okay. And so, with no decay effect, that means that essentially the price benefits in your analysis stay the same for the entire 20 years of the OREC schedule, right?
Yes, that's what the regression shows.
And I guess theoretically infinitely. Right. So do you have the direct testimony of Mr. Chang with you? I have a copy if you need it.
Yeah, I don't think I have. I have some data responses, but I don't think I have the testimony.
Yeah, here I'll.
Thanks.
I did too.
So on page 28, line 12, I'll give everybody a second to get there.
Yeah, I'm there.
So there it states, at a high level, customers and other generators will respond to shifts in the supply or demand curves. Lowering energy prices may increase demand for electricity and may result in generators retiring sooner or delaying new generation builds. Do you disagree with that statement?
I would say that that is the general theory of an efficient market when you talk about forecasting wholesale energy markets.
Okay, so if I can sort of restate it, to put it another way, the offshore wind coming in and increasing supply means lower energy prices, but that means that other suppliers might react with early retirement decisions or delaying new generation, right?
Yeah, I think one key thing there, though, so there's what I would say there can be counterbalancing impacts, of course. Agree with your generators retiring sooner or delaying new builds. The one thing, though, that it's important to point out, too, is I would call those numerator impacts. The other is the increase in demand for electricity. If that were to happen, the other thing that would need to be considered by the Commission is now the denominator over which you're spreading all those ratepayer costs are going to be wider, so you're going to have a bigger denominator. So any impact in terms of the ORECs on ratepayers could stay the same, it could go down, it could go up. These are all kind of seesaws, right, that you'd have to understand exactly where they go.
Yeah, and you just mentioned load growth. Like if you increase demand, general economics is you increase demand, that could also increase like price, right?
It would depend on the supply that enters the stack. One thing that, we're kind of witnessing in some areas of the country right now, Texas and California being some of those that with the influx of zero production cost generation that is entering the stack, so your wind and solar, has actually led to a decrease in power prices because of that more efficient generation coming in.
Okay, but by, again, sort of not having a decay effect, your analysis is essentially assuming that the same lower energy prices from the offshore wind are going to be the same over the 20 years and basically forever, right? If you don't include any sort of decay or change in the price impact.
Correct. It is assuming a consistent change in energy prices over the duration of the study period. And I would say that was, if we go back to the proceeding in, again, 2021 or 2022, the round 2, some people that were here then may remember this was, it was a discussion at the time of how ICF had done their forecast, and that they sort of assumed these seesaw effects would ultimately got to a place where it was very hard to discern what impact an offshore wind facility was having versus someone building a solar farm in the western part of the state, and it becomes kind of a theoretical, almost circular argument in terms of deciding who has the exact impact. So yeah, I understand what you're saying.
Thanks. Nothing further.
Okay. Staff?
Good afternoon. Staff has no questions. Thank you.
Okay, redirect.
Yes, thank you. Briefly, Mr. Repsher, Maryland made a change to its law in 2022 with respect to how the OREC is paid for. Could you describe that to the commission?
Sure. Under, I believe it was called the Power Act of 2022, there was a pretty significant change made to the actual accounting of how ORECs would be passed through. So previously, my understanding is that, kind of as going back and forth on the with the Office of People's Counsel, it was the burden of the retail providers to effectively pass through that cost to their customers. Noting that that would be, I don't know, scientifically an accounting nightmare for some of them, what was changed in 2022 was instead to institute a non-bypassable charge on the transmission portion of bills that accrue to customers. And so by doing that, you had entities like BG&E, Pepco, others would be responsible for coming up with the cost, also netting off the revenues that the facility sells to ultimately get a net cost that they then pass through as a non-bypassable charge to ratepayers.
No further questions at this time, thank you.
Okay.
Sorry, Your Honor.
Yes,
Can I mark the DR as OPC Exhibit 1 at this time
Okay,
and ask it to be admitted?
No objection.
so admitted. Commissioner Sussman.
Okay, so I actually need a little bit of education, so I'm
I like to
hoping you're.
talk, so okay.
So I'm hoping you can help me through this. So that I understand, the project is going to benefit from an investment tax credit and the OREC. So, and I'm assuming that the company has taxes to pay. So it's not a refundable tax credit, is it, or is it?
Without getting into how U.S. Wind is going to administer its tax burden, there is a third rail or second rail where there is a credit transfer market. So they could, it's called tax equity at points. So historically, that's been a lot of the big banks with tax burden. They will enter into a contract where they effectively buy the tax credits.
Okay.
There is actually, with the Inflation Reduction Act that was passed a couple of years ago now, there is also there's a burgeoning marketplace, if you will, for probably I myself could go buy some of these if I want, but yeah, there is the ability to monetize them.
Okay.
Multiple ways, yeah.
But we have sort of a pot of money through the OREX, and then a pot of money through this ITC, however it is captured, and then where the company is going to make its money is then through the sale of power into the energy and capacity markets.
Yeah, let me reframe that a little bit, if that would be okay. So let's say, using really round numbers that aren't going to be applicable exactly here, but let's say it costs $1,000 to build this wind facility. About, let's say, $30 of that will be, or thereabouts, will be paid via this tax credit, right? So that reduces the cost of the facility to $700, let's just say. Based off that $700 estimate, that's where the U.S. Wind team has come up with the bid price that they need, which is what you all see in their application. So that is a fixed set of money that will be paid by the state, ultimately ratepayers, to U.S. Wind. Now, to offset that burden on ratepayers, there are really two impacts. One is direct, in that when U.S. Wind is generating, when they're selling capacity into the PJM capacity market, any revenues they receive from PJM for those sales will then be redistributed directly to the state for use to offset those costs for ratepayers.
Right, and that was going to be my next question. So how is that determined?
In terms of what the price is?
Well, so you've got the company bidding in, and you're sort of recognizing that they're going to bid in a price that's optimal. So they hope they're going to win the bid, and that they're going to make money in the bid that they're offering. How do you determine, or how is it determined that a portion of that is savings, and how is that then distributed back?
Yeah. So the way that, and this comes back to the Power Act of 2022 in terms of how it would work. So on a annual basis, each utility will be assigned an obligation for ORECs, and they will then have on their accounting books whatever that assigned OREC cost is. So this would be, again, if U.S. Wind has bid in $150 per megawatt hour, for example, then let's just take Baltimore Gas and Electric as an example. They would know that for all the ORECs they're assigned, they would have to pay them a maximum of $150 per OREC during the upcoming year. Now, why that's a maximum is because every hour, every day, U.S. Wind will be bidding their generation into the PJM market in the day-ahead and real-time markets. When they are dispatched, so they'll be bidding in at effectively $0 per megawatt hour because they don't have any variable cost. They will bid that in and then receive whatever the clearing price is in the PJM market in that hour. So all of the revenues that PJM says that U.S. Wind gets, instead of those going to U.S. Wind's coffers, instead those revenues will get redirected to BG&E or PEPCO, or based on the allocation of their OREC obligations. So let's say, just as a brief example, in this hour, the OREC cost is $150 per megawatt hour. Let's say, for whatever reason, in that same hour, the market clears at $90 per megawatt hour. Then that means the cost that ratepayers ultimately will have to pay in that hour will be $150 minus the $90, which is $60 per megawatt hour for that 1 hour, or for that one OREC.
Okay, because the company is going to get that 90. Okay, and so they're going to be basically short 60. But
Yeah.
if the clearing price is higher than the OREC price, that's where the savings comes in.
That is part. Well, that is
generally.
Generally, yeah. The other savings that come in as well is just because of, if you're familiar with a merit order stack or dispatch order stack, which basically stacks generation from lowest cost to highest cost. By putting U.S. Wind as a zero variable cost unit, it kind of goes at the bottom of the stack. So it also has the propensity to lower overall energy prices for all other purchases that need to be made as well that aren't directly related to the OREC. So those are other savings that can accrue to ratepayers as well. But those are indirect savings that just happen because of a more efficient marketplace.
Okay. Now, the non-bypassable charge on transmission. Okay. Is that a kilowatt hour charge? I mean, or is that a demand charge?
That's a really good question. I think I'm going to go from memory because it varies by ratepayer class. I believe for residential ratepayers, it's a volumetric charge, so every kilowatt hour. I believe, though, for C&I customers, it's most likely to be a demand charge based off their peak demand contribution. So what I would guess is that the utility would say from non-residential customers, I need to get this much money from ratepayers for this cost, and they allocate it out based off those demand charges.
Okay, so for residential, if the residential is not on an SOS, how will the utility know what the volume is?
Yeah, so a utility, regardless of whether a customer is on SOS service or with a competitive retailer, ultimately BG&E, just because I'm going to keep using it as the example,
That's fine.
they're ultimately responsible for the metering. So they actually keep track of what people are using, regardless of who they're actually buying their power from. Again, because they're responsible for the wires to get the electricity to the house. So what ultimately happens is they will then pass that data on to the competitive suppliers if a customer is on their service. But BG&E and PEPCO, they all have visibility on what customers are using.
Okay, and then for the non-SOS, the utility will charge both the demand charge and then this surcharge? And will they see the surcharge on the bill?
It's a good question. It will be on the bill. I guess it's to be determined, or I just don't know the answer if that would be embedded in on the other T&D charges or if it gets called out as a specific line item. That's probably a regulatory question that I'm just not aware of.
Okay.
So.
All right. I think that's all I have. Okay. Thank you.
Yep.
Commissioner Richard.
Okay, thanks.
Commissioner Barbe.
Yeah, thank you, Mr. Chairman. So I'm not clear on the varying arguments for analyzing over 20 versus 30 years. So sticking as closely to standard English as you can, please explain the rationale for your using 30 years.
I will. I grew up in Southwest Virginia, so I will try to use the my what I grew up. Okay. Firstly, I'd like to say when you talk about the ratepayer test that the legislature has put out there, which I will say is a good thing because most of the other tests in other states where I have testified, it's kind of a bit more cloak and dagger with regard to what the actual test is.
Okay.
But here, while the test is very well defined, the kind of time frame over which one needs to look at the impacts of the contract is not defined. So there's a couple of ways one can go about that. The first is to just look at the impacts over the 20-year period of the contract. So we know that over 20 years there's going to be a cost for this contract. So that's a knowable thing. Then let's look at what are the savings over that same 20-year period. So that's sort of like the minimum of what you would look at. The maximum you could look at is saying, okay, well, just because this contract is 20 years, these are 35-year assets. So just because that contract ends, U.S. Wind isn't going to tear down the facility. It's still going to be there. So after 20 years, ratepayers are not paying any cost for it. However, any impacts that it induces in the energy market in terms of lower energy prices are still going to remain there and be a benefit for those ratepayers. So when ICF looked at it over 30 years, they're basically saying, well, for those last 10 years, there's no payment that ratepayers need to make, but they still get some benefit from that facility being there because it's having an effect of lowering energy prices.
Okay, I don't think I completely disagree with that, but let me just say this, though. The cost impacts over the 20-year of the contract are very direct for ratepayers, but after the contract, I would think that the benefits are sort of partial, and so do you in any way work that into your figures, or do you just recalculate based on 30 years?
Yeah, I guess it's a good question. A couple ways I'll answer that. Firstly, when U.S. Wind, when we ran the analysis for U.S. Wind, we were actually only looking over that 20-year period, so we were showing the facility passing just under those 20 years. After the 10 years, the way that I think ICF accounts for the same, they're not like applying a specific, uncertainty percentage, if you will, to those numbers. But what I would say is that far out in time, the amount that you're discounting those back to today's dollars that's over 20 plus years at that point. So the impact on the analysis would be relatively minimal compared to the first 20 years.
Okay. I'm going to have to think about that a little bit, but thank you.
Sure.
And one last one on your, and it says it's your confidential testimony, so if you cannot answer this, don't.
Okay.
Obviously. Boy, I captured the concept of confidentiality, didn't I?
Yeah.
But I'm just noticing that between Marwin expansion, Momentum 1 and Momentum 2, the levelized costs go down. I mean, I can't think of a concrete reason why that would happen. Is it just the kicking in of economies of scale? What broad phenomenon is causing that to happen?
Yeah, and so without getting into specific numbers and also noting that the specific pricing is something that the U.S. Wind developed based off their financial model. My understanding, though, is that with each incremental phase, you're getting economies of scale. So the first phase is getting built out, and there's a lot of, infrastructure that may not need to be repeated again for the subsequent phases. And so the more that you're able to build out those megawatts in the different phases, the more savings that accrue to that incremental phase. So I think, I know that is the reason that you're seeing that decline.
Well, the reason I want to understand this is I know that the undersea cabling is going to be, I presume that's going to be all, again, if this is confidential, don't answer. I presume that that's the biggest chunk of cost that's getting spread over the build out of the project, because each individual field of turbines is distinct. You're building new, it's almost like a variable, from the perspective of the entire project, it's variable, but I would assume that it's the cabling and transmission facilities that are the cost that is over which the greater amount of transmission is being spread.
I think your explanation is very plausible and may be the case, but that might be something for Mr. Filipowski to answer in terms of the actual. I'm just not aware of the exact timing of the layout for some of those cables. So.
Okay, all right. Well, that's fine.
Mr. Filippelli.
Filippelli, sorry, Grabowski, Filippelli. Sorry,
you
sorry
got
about
at least
that.
one consonant correct.
Sorry.
Thank you, Mr. Chairman.
So this COD date that you had talked about is equivalent to the operational date that we use for other energy projects. Sort of.
Yes, Mr. Chairman.
Okay. And I take it that from your view, any of the delays that might happen in that COD date probably happen at the front end of the process as opposed to once they start construction and building these things.
Not being a construction expert, I think that is likely the case unless you were to get some odd storms in the Atlantic during construction.
Right. Yeah. So absent, sort of acts of God and stuff like that. So explain to me a little bit more about how, when you were having the discussions earlier about how the other entities are factoring in when this thing's going to be part of the mix. I mean, at what sort of dates are they, or milestones are they looking at to think, this, they say it's going to be out, the COD date is, 1/1, whatever, and it's actually going to be that. So.
Yeah, it's probably easiest to answer that in terms of how we think about it, and this in PA Consulting in terms of generation projects generally. And this has been the way we've thought about it now since deregulation back in 99, 2000. Really, there's three kind of criteria that we like to see, and usually it needs to be 2 of 3 before we'll consider something firm. The first is permitting. So that probably is not a surprise that you need all of the various permits and understanding where they are in the process and whether or not they're going to be awarded. 2 would be a contract. So here talking about the OREC contract, being approved. But then thirdly, you would want to have reasonable certainty on when construction is actually going to start. So I would say if the permits are in hand, the OREC's in hand, absent any updates from the U.S. Wind team and those in the kind of monthly or quarterly reports they have to file in terms of delays in construction, then that will be enough for market participants to believe that a project is coming online. Similar, like right now, the nearest project to Maryland would be the I think it's called Coastal Offshore Wind that Dominion's developing in Virginia. So that's currently we're having to factor that into our analyses, that's coming online, I believe, in 2026, 2027. And so when we're doing our forecast now, including when we looked at the impact of this facility, we made an assumption that, okay, we think this is going to come online in 2027 because of where it is in its process.
And so the apart from the amount that's covered by the OREC, as you discussed, the output from this facility, once it's online, gets sold into the PJM system. So we've seen all these estimates lately about what capacity prices are going to be, and certain things they're asking us to do. So, I mean, how does that factor into the analysis for this, or are you just, whatever it is at the time it is, so.
It's a very good question, and I would say this analysis was done prior to the latest PJM auction results, which cleared significantly higher than I think most market participants, including ourselves, had factored in. And I would commend the Office of People's Counsel for the report that I think really woke people up, and now there's depending on who you ask, a grand bargain of sorts being talked about in PJM in terms of trying to reform the capacity market so these impacts aren't felt as much. And so I think that was quite a good report. So effectively, we are basing it on what we think the supply and demand balance will be going forward for capacity prices, and it also at the time was based on what we thought the structure of the capacity market would be with regards to all the parameters that are used to determine prices. I would say if we were to rerun our forecast now, it would show capacity prices quite a bit higher for the first few years when the project comes online. And the impact thereof would be making it easier for the U.S. wind to pass the various ratepayer tests, because now ratepayers are getting the benefit of those higher capacity revenues that are then able to offset those gross OREC costs.
Okay, all right, thank you very much. So, given the fact we've sort of changed up the schedule here a little bit, we're actually going to go to the Department of Natural Resources witness. So I actually need somebody at the table to make room for DNR's counsel so that she can bring up her. Actually, what? Yeah.
Good afternoon. Emily Vinieri with the Maryland Office of the Attorney General on behalf of the Department of Natural Resources. I would like to call our witness, Catherine McCall.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Sure, my name is Catherine McCall, C-A-T-H-E-R-I-N-E, McCall, M-C-C-A-L-L. Business address is 580 Taylor Avenue, Annapolis, Maryland, 21401.
Thank you.
Good afternoon, Ms. McCall. Do you have before you a document entitled Direct Testimony of Catherine McCall, dated October 7th, 2024?
Yes.
And does that document contain 11 pages of written testimony?
Yes.
Chair Hoover, I would request that Ms. McCall's direct testimony be marked as DNR Exhibit 1 for identification purposes.
So marked.
Ms. McCall, was the document identified as DNR Exhibit 1 prepared by you or for you under your direct supervision?
It was.
Do you have any revisions or corrections to your pre-filed testimony marked as DNR Exhibit 1?
No.
If I were to ask you the same questions today under oath as were asked in connection with your pre-filed testimony, would your responses be the same?
Yes.
Do you adopt the pre-filed testimony marked as DNR Exhibit 1 as your own sworn testimony in this proceeding?
I do.
Chair Hoover, if there are no objections, I respectfully request that DNR Exhibit 1 be admitted into evidence.
So admitted.
Ms. McCall is now available for cross-examination and other questions.
Okay, Sierra Club.
No questions.
Earth Justice.
No questions.
OPC.
No questions, Your Honor.
Applicant.
One brief question, Your Honor. Ms. McCall, thank you for being here today. If you would mind, just for the benefit of the Commission, could you describe the efforts that U.S. Wind and MDNR have engaged in around fisheries mitigation and the memorandum of understanding and the condition that the parties agreed to recently?
Sure. I know fisheries compensation is a new topic in these proceedings. About a year or two ago, fisheries compensation really started becoming a more active topic of conversation in offshore wind in Maryland. And in July of this year, both the Department of Natural Resources and U.S. Wind signed a letter of intent making commitments to fisheries compensation. We recognize that there are a number of impacts that the development of offshore wind will have on offshore fishing operations and onshore fishing. In the Bureau of Ocean Energy Management's work, and their permitting processes, they acknowledge that as well. And they account for some of the different federally managed species. In Maryland specifically, particularly with the development of the operations and maintenance facility that is planned, there's state-specific impacts that aren't recognized in those federal permitting processes. And so when both the Department of Natural Resources, State of Maryland, and U.S. Wind entered into the letter of intent, it was a way to kind of make that acknowledgement. The department sees those and recognizes those impacts. We're hearing it from our fishing community on the coast, and U.S. Wind has acknowledged through that letter of intent and in the condition that we've worked on with U.S. Wind that we want to address those and develop 3 different forms of compensation. So we've continued to have active conversations with U.S. Wind and the department. DNR has also engaged the fishing community down in Ocean City regarding some of those impacts to seek their feedback about what their concerns are so that we can ultimately enter into a memorandum of understanding that reflects some of those concerns.
You're familiar with U.S. Wind. They have an order from the prior OREC to build an O&M facility in Ocean City. Are you familiar with that?
Yes.
And have you had discussions with U.S. Wind, or is there any plan, which may also be included in the conditions, that U.S. Wind to specifically address any possible fishing impacts at those exact locations where the O&M facility is actually planned to be located, which, yeah, that's a question.
Yeah, I'm familiar. There's 2 properties we understand that U.S. Wind has option agreements on. The forms of compensation that are referenced in both the letter of intent and that we continue to develop, which ultimately would go in the MOU, a 3rd category is a community resilience fund. That's something that would not be reflected in any of the federal permitting processes, and does recognize that should those 2 properties be developed into an operations and maintenance facility, it displaces all commercial fishing landing facilities in the state of Maryland that are available on the coast. And so that Community Resilience Fund allows for U.S. Wind and the department with fishing industry feedback to really flesh out what some of those options may be to help, whether it is identify a new location, come up with some type of other solution in that area. So that is one of the forms of compensation that's currently under development.
Would it be fair to say that MDNR is actively speaking to and engaged with that community to understand their interests, and that the MOU will happen, shortly after MDNR has identified those interests and sort of understood them, so that the funds can be established and allocated appropriately?
Yeah, and I know in our data request, we did provide feedback about the current status of that, all 3 of the different forms of compensation. The Resilience Fund is, I think at this point, the least scoped out in terms of knowing exactly what that will look like, or how much money would go toward that. The department did hold a meeting on September 24th with the commercial fishing industry to have a dialogue and about what some of those concerns were, what some of the different fishing interests were. And so we will continue to do that. We're looking to hold a 2nd meeting in November, and we're having ongoing discussions to understand what those options might be and how we may ultimately define that portion of the MOU.
Further questions?
Okay, Commissioner Richard.
Excuse me, I just have one
Oh,
question.
I forgot.
Commissioner.
Yeah,
Yes.
never mind. Yeah, in fact, I purposely sent you last. And okay, go right ahead.
Thank you. Harrison Chair on behalf of staff. Just got one question for you, Ms. McCall. Do you happen to have a copy with you of Staff Data Request 1, which you are author of?
The DNR one?
Yes. Okay, I want to distribute copies of this for everyone. Do you recognize the responses before you?
I do.
And these were made by you, correct?
That's right.
Do you have any edits or corrections to these responses?
I don't at this time.
Okay, at this time, staff would like to mark staff data request number 1 to MDNR as staff exhibit number 5.
So marked.
And staff would like to move this into evidence.
So admitted.
Thank you. No further questions.
Okay. Commissioner Richard.
No questions, thank you.
Commissioner Barbe.
Thank you, Mr. Chairman. I'm just curious, when did you begin the process of reaching out to the fishing industry stakeholders?
For the purposes of the letter of intent and the MOU that began on September 24th, 2024, DNR does hold twice a year coastal recreational fishing meetings, and staff from our office have been going down to those for the past couple of years, providing
Okay.
updates.
So you've been engaged at that level for a bit of time?
Awareness
terms of
of
observing.
offshore wind, correct.
Yeah. Okay. Thank you very much.
Good afternoon, Ms. McCall. So in your testimony, you're asking us to include the fisheries compensatory mitigation as an approval condition. So that would go beyond simply a letter of intent or an MOU. But it sounds like you're sort of making a lot of progress, or at least that's the sense I had from your the questioning from the applicant. Is that true?
We are making progress on the MOU.
Okay, so is your concern in including the condition in an order, is your concern that you won't get there, that you won't come up with an agreement about mitigation?
I think both parties are making good progress. Unlike in some of the other states where these types of agreements have been put in place, they're usually tied to a particular state permitting process. In Maryland, since the only physical location associated with the facility is the O&M facility, there isn't a broader permitting enforcement mechanism in place that would allow for that continued understanding and adherence to this type of agreement. And so our hope is that through a condition on in this case would help to make it a very Maryland-specific process. It really is the only one that exists at this point.
But,
to do
but
that.
you're not asking us, I mean, we could have a condition that says just come to an agreement about compensatory mitigation, but we won't spell out what that is. So that if you are, if you're not happy with the results, I guess you'd come back to us and tell us you don't believe that it's within the spirit of the condition. Is that?
Yeah, we're not asking for, I think both parties do intend to enter into an MOU. At this time, I think it's by January 13th, 2025, the parties could extend that. We intend to do that. We would like for that MOU to be recorded as part of a condition on these case proceedings.
Okay, and BOEM doesn't require this?
BOEM's record of decision does require that U.S. Wind contribute to direct compensation for federal, and the data they use and the requirements that they have really pertain to just one portion of the fisheries species offshore. So I'm not a fisheries scientist, but without getting into too many specifics, there's some species that are caught commercially and recreationally that require federal licenses. There's a variety of other ones that are very important to Maryland's fishing economy that are not managed through federal species, and so BOEM cannot require or account for those landings, those revenues to be included in their requirements.
Okay.
There's also state-specific things, such as the operations and maintenance facilities. So BOEM recognizes there are shoreside impacts, but the scale of the potential impacts by displacing the landing facilities in West Ocean City with the O&M facility, that's just at a scale that is not conceived of in
Okay.
BOEM.
No, I appreciate that. And you're not concerned about whether this is within our jurisdiction to require this? You believe that this is within the commission's authority to include this as a condition?
I'm not terribly familiar with the entire breadth of the.
No, I appreciate it, but if you're asking us to include something, a condition, I'd like to know that you sort of have looked to see that it's something that we have authority to do. And there are lots of things we'd like to do, and I'd like to have more takeout places around the commission, but we don't have authority to do that. And I'm not like making light of it. I don't want to have this be put in an order and then find out that it's not something that we have authority to do. So I guess my question was, is that something that you've taken a look at and you believe that we have authority to require this?
I've personally not looked into that, but can get back to you. I think the one thing that we are aware that already is reported to the commission are some of the investments and progress toward environmental goals and environmental studies and those types of investments. And I think the fisheries compensation, while it hasn't come up in these proceedings, is another very important aspect.
Right, and that's actually the only reason, because
Yeah.
it's new. I mean, I did see that in your testimony. I just wanted to know if this was something that you had looked at. I guess to the extent, that's sort of my way of saying that if you can provide us with some rationale for why it's within our authority, that would just give us greater comfort. So, okay, that's all I have.
So you're testifying on behalf of Department of Natural Resources writ large, not the power plant research program?
That's correct. I sit within the Chesapeake and Coastal Service at the department.
Okay. And did you happen to see the public hearing that we had with the folks in Ocean City?
I did. I saw half of it.
Okay, did you actually, if I remember right, there actually was somebody representing the fisheries community, I forget the exact title of the group, that expressed some concerns about the offshore wind project.
That's right. I saw his testimony. Sonny Gwynn, he is, I believe, the president of the Watermen's Association of Worcester County. I did see his
Now,
comments.
is that one of the folks that you're talking to?
Yes.
Okay, so without, I guess, going too far down the path on this, I mean, I realize there's a whole bunch of different fisheries and entities. So who exactly are you dealing with in trying to put this thing together?
Yeah, so the department's efforts right now, we pulled all of the different federal license holders that are in Maryland's record books. It's not a large industry in Maryland like it is in other states, but those are the folks that we have reached out to.
Okay, but I guess what I'm trying to figure out is the commercial fishermen, recreational, because I know there's all types of fishermen, so who all is going to be part of this potentially compensated group?
It's the commercial fishermen, and then it's a slice of recreational. It's those that are hired to take folks out on paid fishing trips.
So if I go out in my boat on my own and go fishing and don't catch something because of the wind turbine, I'm not part of this group.
That's correct.
Okay. And I know you haven't worked out all the details on this, but is the thought process that U.S. Wind is going to provide a set pot of money every year or at one time, or, I mean, to the extent you can explain to me how this process you think's going to work?
Yeah, so there's 3 different forms of compensation. We're hoping that we can follow some of the models that have already been established in other projects, and most of the time those are one-time payments, lump sum. It isn't something where it would be every year there's money put toward it.
Okay. And is it because of the construction of the turbines, or actually the existence of the turbines once they're constructed, that's the reason that we have to compensate the fishermen?
It's a bit of both. During construction, and we understand that U.S. Wind will be phasing in the construction. During construction, there will be areas that fishermen won't be able to go and fish. We'll say the entire project has been completed. For a number of years after that, a lot of the compensation approaches assume that there will be some kind of impact for a certain amount of time and the ecosystem will recover and then allow fishing again. So the compensation is general, at least BOEM's approach is that there is usually compensation during the construction of it for 5 years of the operations, and then during decommissioning when there's again some of those impacts where folks can't fish during when the turbines and facility is being removed.
And again, maybe you haven't figured this out yet, but the means of compensating the fishermen, is U.S. Wind going to do that? DNR going to do it?
Yeah, it's a good question. Some of the projects to date have had to set up a third-party fund administrator. 11 states from Maine down to North Carolina have recognized that that can create one process in one state and another process in another to submit claims. So those 11 states for the past couple of years have been working to establish a regional fund administrator, and we understand that and have been involved in that process at the Department of Natural Resources to help develop, and an RFP went out on behalf of the 11 states earlier this year. NYSERDA put that out, and a vendor should be selected who then would work across the entire Atlantic region to help develop a consistent, fair, and equitable process that if you fish in New Jersey or Maryland or Maine, you're going to be experiencing a similar claims process. So U.S. Wind would probably, assuming that the regional fund administrator is available when they would need to make payment, the funds would be administered by that 11-state regional fund administrator. That is our goal.
I hadn't really thought about the fact that people that fish from Maryland fish not just the Maryland waters, but because after a certain point, it's all federal water, right?
Right, after 3 miles.
Yeah, okay. Now, along the lines of the questions that were asked about, making this a condition, since the deal is not signed, sealed, and delivered, I mean, how do we go about putting in words the condition to, put into operation this agreement, and what happens if, for some reason, the agreement between you and U.S. Wind goes south? So.
Yeah, DNR and U.S. Wind have already developed a draft condition for the Commission's consideration. Both parties are making good progress to date in developing out from the letter of intent to an MOU.
Without holding you to this, any idea when the MOU might be a done deal?
As written right now in the letter of intent, it's January 13th. The department did receive a request from the Watermen's Association of Worcester County to consider an extension, and we are working with U.S. Wind to explore that. That would probably take it around about May if that did move forward. I'll also add that we, in my direct testimony, we did reference that we are working with the Delaware DENREC because a lot of the fisheries offshore impacts are similar. We've been tracking all together, so we are looking at that extension. So that would, at the latest, potentially be May 13th of next year.
And final question. So you're essentially the negotiating agent on behalf of the fisheries industry with U.S. Wind.
We're not negotiating on behalf of the industry. We're trying to develop an MOU. It doesn't obligate the fishermen to take advantage of equipment upgrades or to participate in a claims process. We're trying to kind of scope out what are those forms of compensation that are really important for Maryland's fishermen, and create funds that would allow them to say, I have experienced a loss in fishing within the offshore portion of it or the transmission route, and be able to receive funds to compensate for that loss, or to receive training and navigational equipment upgrades to enable safer fishing offshore. And then that third part is really to dig into the operations and maintenance facility impacts in West Ocean City, and try to figure out, at this point, we believe it probably is financial compensation to create or explore some type of option, and hopefully engage all of the parties down there to be able to have them figure out what would work for them to make sure that their industry can continue to exist in Ocean City.
So I should not assume that if you get to this MOU, that in fact takes care of the opposition by the fisheries and the watermen to the offshore wind project.
No.
Okay. Okay, fair enough. Oh, go ahead.
Okay. So just to follow up on the chair's question about some language. So you have some draft language that you've worked on with the company.
We have.
Would you share that with us? And perhaps.
I think it's part of the deal.
So,
Your Honor, I'm just.
I was just going to reference in Laurie Jotzowitz's rebuttal testimony, the draft
okay.
condition language was included.
Okay, and that's language that the company is in agreement on. So we can lift the language and just put it in an order.
Yes, Your Honor, and also the staff DR that was just admitted into evidence a few minutes ago has the same language.
Oh, okay. Well, that makes things easy. Okay, thank you.
And of course, we agree to it, as Mr. Collins just
Well, I'm
hit me.
assuming that that nobody here has a problem with the language. Okay.
And one final question. I mean, has there been discussion at this point of the amount, or is that somewhere down the road?
It'll come out, it will be memorialized in the MOU that is signed at the end. I think kind of in the data request, each one of those different forms of compensation is at a varying level of development.
I see. Okay, thank you very much. So that actually is all we are going to do today. And then we're going to come back tomorrow with OPC's witness and hopefully maybe finish up tomorrow. Okay, thank you very much.